Yes.
Right. But with pension one pension matter, my lord, service is complete, my lord. I'm not getting pension. That's why, my lord, I pray, my lord, this matter will step on 27th of January,
27th.
my lord.
27th is what day? No, 28th.
28.
Ms. P. Bhattacharjee, the learned counsel appearing on behalf of the petitioner submits that she has instructions to withdraw the writ petition. Accordingly, the writ petition stands closed on withdrawal. Interim orders, if any, stands vacated.
May I please, Your Honor? I have filed an IA in connection with the writ petition. It is not taken the record. The writ petition is listed tomorrow and item number 24.
Actually, but it's for it around start of February.
Why?
Part of February. Or on any other day, but part of February. Urgency is there, Lordship.
What is the urgency?
Urgency petition has been permanently stopped by the authority.
Family pension.
No, pension.
Pension has been stopped.
Following disciplinary procedure.
Following?
Disciplinary procedure.
Okay, 2nd of February.
Part of February.
Why?
For the part of February is Lordship Thursday.
2nd.
Lordship.
Okay. I need to mention for listing of a matter, lordship, or admission, lordship. The matter was last listed in 5th March 2025, lordship. But may I please have-
6th of February.
Can it be in the next week? Because lordship, the respondent is holding the post of secretary beyond the prescribed age of 60 years, lordship. And lordship, now he is indulging in the lordship.
Okay, 30. 30.
Obliged.
Motion tomorrow.
But I beg to mention about listing, my lord. Admission column petitioner 70 years. So his pension benefit is pending, my lord. Already everything is done, my lord. That the paucity of time not.
7th. 7th.
I like to mention for listing of
Tomorrow. Tomorrow or Friday. When do you want? Tomorrow or Friday?
Friday also.
Oh, it's no. Friday is a holiday, na? Okay, tomorrow.
Your worship, I beg to write a state my lord for adjournment.
Item number 6. Your name?
A. Malek. A. Malek.
You are not there.
No, my lord. I'm
Then don't ask for adjournment if you are not there.
council.
You appear when the matter is taken up, then we'll accommodate you. Next.
So, with respect to point number 2 of the receipt, my lord, I'm seeking an adjournment of the Lord S.K. Tata. My lord, he is on Kolkata for some medical emergency, my lord. I have circulated the adjournment secretary.
Item number 4.
Number 4.
Okay, at the request of the learned counsel appearing on behalf of the petitioner, matter stands adjourned to be listed after 4 weeks.
Item number 4, my lord.
Item number 4. Is there any interim order?
Madam, therefore, listing the petition for motion here, stick on 22 minutes.
Last listed on 6/11/25 regarding reading statement in service,
Matter pertains to?
admission, lordship.
I understand, but when the matter pertains to what?
It's been suspended for reading statement.
Suspension. Okay. We'll have it on 2nd of Feb. 2nd of February.
Like,
Six days, first item. Affidavit condition.
As per the last, our affidavit, you have to file an affidavit also, and that's point number 8. Our affidavit has come on record, as well as APLC's affidavit has come on record. both the affidavits come, my lord, but I think
I have also filed an affidavit, my lord, it was called for.
it's called today. He has filed an affidavit, but it's not it. It's called,
When did you file?
Yesterday, your lordship.
it's
Has it
called.
come on list? Mr. Mohanto, what do you say about this thing? About the Rule 68 application?
My lord, that actually what happened, my lord, I have stated in my petition, my lord, your lordship can see my affidavit, my lord. Because in 2010, my lord, I'm background, I'm just pointing, I'm just submitting, my lord. In 2010 rules, there is a lots of complaint raised, my lord. And in fact, there is a challenge made before this honorable court also, at 2010, my lord. In 2016, আচ্ছা, বলো কথা কি? 2016, there is a meeting of the PSC, my lord, they decided to amend the 2010 rule. In that decision is taken in 2016. And also that was also prepared, my lord. And accordingly, that rule was, my lord, came into existence in 2019. But in that, your lordship kindly see, to avoid another complication, my lord, this rule 20, rule 68 says, my lord, the component of two subjects, that is subject of, my lord, compulsory papers and optional compulsory paper and, my lord, bhavavas, not optional and others. But in 2019 rule, my lord, which is, my lord, already 2016, it was, my lord, although they are keeping in mind, my lord, that only the highest mark will be getting, the total mark obtained by the candidate will be counted in the written test. So in that context, my lord, your lordship kindly see, I have given the fraction in my affidavit, is, my lord,
Kindly come to page 130.
130. My lord,
The Rule 68 says that if both the parties, if two candidates gets equal marks,
my lord,
then in that regard, the main subjects, whoever has got more marks
my lord,
would get it.
my lord.
Now, the main subjects happens to be the general studies and general English.
General English.
Now, admittedly, the respondent out here, respondent number
Getting
8,
less mark, I have seen, my lord.
he got 733, whereas the petitioner got 756. Page 131.
My lord. But in
Ha.
written, my lord, total mark, my lord, your lordship kindly 733 and 756. So that will not be counted because 2000, that point of time, 2010 rule was exist. That way, my lord, he has a case, my. But so far is my point of delay. He knows this, knows, my lord, 2017, he knows that his mark, my lord.
Lordship,
He cut off also knows, my lord.
Did you give these marks earlier?
Yes, ma'am. His mark and cutoff mark he obtained in 2017. RTI reply was given, madam. Everything is given. Your lordship kindly seen in the petition, he has,
Mr.
madam.
Phukan, were you aware about this thing?
no, my lord, the RTI which we have, my lord, got the reply. My lord. The RTI reply was furnished to us.
Cutoff to patient.
Because we just got the 901, my lord. So we just got the cutoff, but we, at to my lord, we got it after the thing, my lord. Just show it, my lord, I'll just show it.
Page 43, madam. Your lordship will get you.
43.
Page 40.
Page 43.
This was given at page 43. It was given in 2017.
We got 901, man. So the cutoff which was we did not get, man, the cutoff, the breakdown, we did not get the breakdown, man.
No,
No,
my
here the
lord,
breakdown,
my
here the
lord,
breakdown is there, page 43.
No, only of my thing, my lord. So the, so your lordship kindly sees the, my lord,
Where's,
labor
madam?
inspector, my lord, kindly see the labor inspector is 901. The last cutoff. Lordship kindly sees at page 45 again.
Page
The
40.
cutoff marks. So 901. So we were of the view that since we have got 901, if the cutoff is 901 and ST planes, I'm ST planes, my lord. If your lordship sees at labor inspector, serial number 4, page 45.
901.
So 901. So if I have got 901, why am I not getting it? So that's why I cannot be done the RTI.
So when did you get this thing at page 45?
We got it with this, my lord. So we had.
So,
given
so
the
you got it in,
So when we wanted the.
so
representation-
therefore, in 2017, you came to learn about this thing.
Yes, my lord, but we did not get how much who got, my lord. So we did not get that. And my lord.
No, no, no,
regarding the-
understood.
My lord.
This was in 2017.
17.
So you knew
And
your marks as regards your combined marks as well as everything was given in 2017.
And my lord, and one more thing was there, my lord, regarding when we got the general studies paper.
When did you take steps to get to know about the respond number 8?
My lord, respond number 8, we got to know when the APSC filed their affidavit. That he has got, because we did not know the marks, how much they got.
So therefore,
There were two respondents, my lord, like I said on the last occasion. there were
one
two
respondent got 905.
One 905 and one got 901.
901.
We were not sure who got how much. So
No,
then-
whatever may be.
My lord.
So therefore, you filed the instant writ petition only on the basis of a hunch.
We filed on the basis of three occasions, my lord. We filed it firstly, my lord, which as per the last order dated 6/1, which had clarified, my lord. So the first point we had raised was that it was the question numbers numerical 6, Roman D, Roman 5. That was our first contention, that had we been evaluated properly, then my lord, instead
But
of
you
901, I
came,
would have got 903.
but this is as regards to one Rishikesh Das.
Exactly, my lord.
So that particular person, he got the marks out there, he fought immediately, came up before the court that he number is there. Matter went to the division bench also upheld the single judge's order. Matter went to the Supreme Court dismissed the SLP. And resultantly, thereafter, you have raised this point.
Right. I agree. Last time also, Lordship. this
So
point, your
therefore, I have
Lordship-
rejected
Lordship-
it.
Lordship-
You
Lordship-
cannot be a fence sitter. Now, my question is,
Fine.
your case that yours is 901 and he got 901.
Right.
Another person got 901. When did you learn that respondent number 8 was appointed and got 901?
My lord, we came to know when the affidavit was
No,
filed. My
no.
lord, because the affidavit was also kindly again.
So therefore, after filing of the case, you came to learn. So therefore, from 2017 till 2022, you were sitting.
I'll explain, my lord. I'll explain properly, my lord. Because the other two candidates, my lord, we did not get as to who got 901. That's why we had made them both parties. When the APSC clarified through the affidavit, on the last occasion also had indicated this, my lord, that when the APSC had brought on record that respondent number 7 got 906 or 905 above us, he got on merit. So as soon as that happened, we said on the last occasion also that he has gotten merit, my lord, we have nothing contest with him.
Mr. Fukan, are you not getting my point out here? Do you file this writ petition in the year 2022? You got this 901 you knew about this thing in 2017. Respond number 7 and 8 were appointed in the year 2017. You waited for 5 years and then filing the writ petition, and thereupon, on the basis of an apprehension or a hunch,
No, man.
you are trying to improve your case on the basis of the affidavit.
My lord, just one thing, my lord, query. One point I would like to raise here is that last occasion when your lordship had brought this topic out, lordship, if your lordship sees the order dated 6/1, there, my lord, lordship had said that lordship had asked me which what are the points you are challenging. The first point I had said that, my lord, it's the rule, is the 2 marks which I was supposed to get. So that, my lord, we have dropped. Lordship said if you drop that question for evaluation, we will look into the other aspects you have. So the second, your lordship said that show me any other point which you have, which you can showcase, you can make out a case. So here, my lord, I had made out a case regarding rule 68A. I had said that rule 68A has not been followed. But then, my lord, they said that they have got on the last occasion, they have got the instruction, so they filed this affidavit. So in that affidavit, when I checked, my lord, when we went into the affidavit, we saw that the rule 68A is direct violation. That's the second point we have. And I will showcase that. And third point, my lord, is the one more point which I would last time your lordship had said that if you have any other point, let me know. And my lord, that's the third point is rule 56. Rule 56 also, my lord, has been violated. I will showcase how, my lord. If the lordship comes to just for a lordship fellowship, rule 56 is, my lord, 56 of the 2010 rules. Rule 56 says, my lord, packets containing answer script shall be made uniformly as regards the number of scripts and shall be sent to the respective examiner by the principal controller of examinations, and the examined scripts are to be collected on the specified date. Instructions shall be given to the examiners that no marks should be overwritten and the marks should be given clearly and legibly. If, madam, this part is important for me, madam. If necessary, it may be cut by a line across it, and when the new mark is allotted, may be written over it by putting a signature. Now, lordship comes to the answer, the answer, the score sheet. I'll just this point I had raised in the first this thing, actually, they also have taken into consideration this aspect also. Lordship comes to page 50. This is the, my lord, answer script where they have answer script of the written paper of general English. My lord, kindly see below. They have written 196. First they gave 200. Kindly see total marks. They give 200. They give the marks. They cut it, and there's no signature. Then again they give 198. Then again they cut it. Then again they write in the statement they cut that. And then they cut again. Then they put 196. So after giving me 200, they cut it. And above your lordship sees one more point they cut. They have given signature. Below they have not given signatures. They are doing cutting and all. But as per Rule 56, you have to put signatures. This I had pointed out on the first occasion itself. So the court had taken that also.
My question is, when did you get this?
This, my lord, we got it. These are the 3 points. We got it then, my lord. But the moot question out here is regarding Rule 68. 68A. 68A, we came to know.
Mr. Phukan.
The affidavit is filed.
Mr. Phukan, why should I entertain this if you have got it at that point of time, you did not file the requisition?
My lord,
Again, the question of fence sitter comes in.
my lord, I can, if your lordship again ask me to drop this point also, I can drop it. But my lord, rules.
I am not asking you to drop it. I am rejecting your point.
My-
Where about that? Last time also, I never asked you to drop it.
No,
I said I'm going to reject it,
rejected, my lord, but.
and I have devilly rejected it.
But just one point I just want to, my lord, showcase to your lordship. Kindly, my lord, see, my lord. Rule 68A, which they have spoken about. If your lordship.
No, there is a violation of Rule 68A. No, there is no quarrel with that, there is a violation of Rule 68A.
So.
There is no quarrel.
No.
Now the question is, you develop this 68A
No.
only at the time of filing the writ petition.
No, my lord, because at the time of writ petition, when the writ petition was filed.
So you didn't have Rule 68A.
No, my lord. Rule 68A, but I did not know the marks, how much they had scored. Because they had
Understood.
they had
Understood. Therefore, you came to learn later on. So 68A violation is subsequent to the filing of the writ petition.
No, my lord. The Rule 68, my lord.
Let us see your pleadings in your writ petition as regards violation of Rule 68A.
Rule 68, we have not mentioned it because of the fact that.
So therefore, Mr. Phukan, am I speaking in a foreign language? I make it very clear to you. You have developed the point of Rule 68A post filing of the writ petition. That's it.
That's it, man. Because of that. And Rule 68A.
So as regards the first and the third point, first point I have already rejected on the ground of fence sitter. The third point is also on the ground of fence sitter. It is to be rejected. Now the question is as regards number 2. Yes, there is a violation of 68A. Now, if this is a violation of 68A, then how do you save yourself from delay and latches?
Delay and my lord, last time I had pointed out, my lord, the judgment of my lord, the India Singh, my lord. I'll just showcase to you, my lord. India Singh judgment, it's a latest judgment, my lord. Wherein, my lord, the Honorable Supreme Court has said that, my lord, when there is a. Let me just point it out once.
But Mr. Mohanto, it is very unfortunate that some public service commission, which is a body under Article 323, have resorted to filing an affidavit in this manner earlier, that they have followed Rule 68.
My lord, that's why I'm, in the next affidavit, I have given everything, my lord.
No, and it's
But
very,
I
you have
understand.
given it, but why on earth did they mention it that they have followed Rule 68A?
my lord.
68th. Isn't it a thing which the APSC have resorted to mislead this court?
That not exactly, my lord. Why I'm-
Let's read this particular
no,
paragraph.
Why I'm submitting, my lord?
Now, let's read the paragraph of here. Unless I have the directed filing of this affidavit, it seems to be something wrong.
No, my lord.
Let's see the affidavit filed. First of all, you should not have said that.
No, my lord, your lordship kindly see the our earlier
Kindly see here.
Hmm?
Kindly come to page 101. Paragraph 8. Your affidavit, the first affidavit filed in the year 2023.
Hmm.
Let's read paragraph 8. Subpara.
My lord, subpara I
It
have
is
explained.
pertinent to mention that Rule 68 of the so-and-so provides for a solution in case of two or more candidates securing equal aggregate marks. As such, the Commission recommended Respondent number 8 to the post of Inspector of Labor under the STP. Regarding the averments to the effect that the petitioner secured grand total of 901 and he has qualified for the post under the so-and-so, the answering deponent begs to state that at the time of processing of the results so-and-so, in the case of a tie, the candidate securing more marks in the written examination has been ranked higher. This provision was adopted to offset any speculation of Commission awarding higher marks during viva voce and interview to a select few. As such, recommendation of the Commission to the select respondent number 8 to the post of the inspector reserved for so and so is genuine and devoid of any malafide. Now, therefore, my question is, are you not therefore insisting on Rule 68 and say, unless this affidavit which you have filed subsequently,
My lord,
which is contrary to paragraph 8,
my lord. But probably at that point of my lord, keeping in mind that my lord 2019 rule has come.
or is it that it was kept in mind that this court would never ask as to what was exactly of what person a person have got out there in the written examination? This is a very serious case of
No,
misleading.
my lord, this is not a case of misleading, my lord. Actually, that your lordship kindly see last portion, my lord, there. Because they probably in their mind, my lord, in that point of 2016, my lord, 2016 amendment, my lord. Draft
Have
has
they
been executed.
mentioned anything at page 102? They make it more specific and clear that Rule 68 takes care of
My
a
lord.
situation when there is a tie. And a person who gets more marks in a written examination would get more. Apparently, he has got more marks.
Actually, if your lordship. That is, my lord, 2018, my lord, 19 rules, my lord, that language has been, my lord. Your lordship, there are two more
Huh?
in case of 2019, my lord, that language was adopted. Clearly. In 2000.
Understood, but this affidavit was filed in the
My
year
lord, that, my
2023.
lord, I'm sorry, my lord, that is not a bona fide because
And your judgment does not help you. Give me a judgment on a service matter.
My lord,
Well, this judgment
this-
which has been delivered by Justice Dhulia doesn't help you. This is on a limitation of section 5.
Copying of that particular element.
No. That you can't apply that those people. This is after all, you are taking away somebody's service benefit after waking up after 5 years.
Lordship,
That's a different aspect.
Lordship, and one more thing I would like to point out over here, the affidavit which the respondent number 8 has filed. There, well, my lord, the confirmation has come. Confirmation has come only when the, my lord, this thing, confirmation has come only on 23, my lord. He has been confirmed only on 23, right, whatever. my lord. But my lord, one before my lord, come to that, my lord, I would like to showcase, my lord, one judgment of the Honorable Supreme Court, my lord, which is, my lord, full bench judgment reported in 2020, 20 S6680. This is regarding, my lord, an APSC matter, which went up to the full bench, my lord. And my lord, here, my lord, paragraph 13 to 18 that have been allowed to be read, my lord, is specific, my lord, which says that at the point of time which norms of this thing, that rules will apply. The law, it's what 2010 rules will apply, my lord, so they have done it according to 2010 rules, my lord. So this is there. The law with regard to the paragraph 13. The law with regard to applicability of the rules which are brought anew during the selection process have been crystallized by this rule. It has been held that the norms existing on the date when the process of selection begins will control the selection. An alteration to the norms would not affect the ongoing process unless the new rules are to be given retrospective. Now, my lord, after that, my lord,
No, it is nobody's case out here that the 2010 rules does not apply. It is their very specific case in paragraph number 10. They have not mentioned about any 2019 rules. They say about 2010 rules. And as per 2010 rules, you have a case under Rule 68. But tell me, why after 5 years?
lordship, that is one. case.
Show me one judgment in that regard.
Rama-
Because there are many judgments passed by the Supreme Court in respect to pertaining to the service matters. On the ground of delay, the court has dismissed it. On touching on the seniority, you cannot be allowed to do it.
So, my lord, one more thing, my lord, the affidavit which has been filed by the respondent number 8 has been filed wherein, my lord, he has given a confirmation that his confirmation was done only in the year 23, recently. I think the affidavit is not there. So it is just 23, he has been confirmed. His service has been confirmed. So he was on probation till then,
So
22. And my case has been filed before,
are you not challenging the select list?
challenging.
Are you challenging his probation?
Challenging is correct, no.
Are you challenging his probation? No. So therefore, come to the point. Where is it?
Judgment also, my lord,
Where? Where is it?
Also a paragraph, my lord, where there is a kind of delay. Can be, my lord, what it says, no. Paragraph 20, my lord. Whether as it may the High Court having been approached, the appellant would close the gates, the sole reason for dismissal of the repetition was premised on Sweat manner, invoking which while delay and it could decidedly have to grant so manner. Either no explanation. A number of factors need to be considered, my lord, before a repetition is dismissed on the sole ground of delay and legislature. In this case, my lord, since I have merit, my lord, in this matter, and my lord, I'm agreeing, my lord, I'm agreeing that there is a delay, my lord. on-
Your agreeing would not help your
No, no, no,
case.
but
Kindly
it does not
come to
dilute my
No, kindly come to paragraph 22 of this judgment. In the present case, neither there is any accrual of any parallel right of a third party, nor could grant of relief cause confusion and public inconvenience. So how will this judgment apply to your case? Here there is already a right which has been created upon him when he has been appointed in the year 2017.
Legally, he has got it, my lord. The
So
58
what?
marks I have got more, my lord.
So
And
what?
my lord, had I not.
The
my lord,
illegality is not so gross. No, obviously, this was never your case earlier. It is because of them you have got a case. I think the APSC was in hand in glove with you. Otherwise, this 68 was never brought up by you in your pleadings. They themselves came up and said that they wanted that put the feet in muddy waters out there by mentioning about Rule
The
68.
breakdown was not given. They said that, my lord, they have no, my lord. They have categorically stated in their affidavit, my lord, that they.
Mr. Fukan, you try to convince me on your delay.
Delay. Fine, man. I'll give me a date may be given. I'll bring judgments, my lord.
Absolutely today. That is why the matter has been
And my lord,
fixed
one more thing,
today.
my lord, no, my lord, the affidavit filed by the respondent number 8 also, my lord. There, my lord, confirmation has been given on 23. And
How
my lord,
okay, then should we dismiss your petition on the ground that you have not challenged the confirmation? Okay. No, okay, on that ground, let us dismiss it. the petition has become infructuous. Huh?
I'll address on the delay part, and
Then
then my lord, I would like.
That is what you are to address today. Then why should we have it again? We have already spent half an hour,
Regarding-
Okay, then
Yes, my lord.
15,000 cost upon you.
My lord,
Upon you, you are small, there's a half an hour of the court's precious time.
For the indicting judgment, my lord, for the indicting judgment, paragraph 14, there can be no quarrel on settled principle or law that delay cannot be condoned without sufficient cause. But my lord, a major aspect which has to be kept in mind is that if in a particular case the merits have to be examined, it should not be scuttled merely on the basis of limitation. If this is a case where the limitation, my lord,
This is section 5.
Exactly.
This is section 5. There's a difference between concept of delay and latches and concept of section 5. Mr. Bhuvan, don't make these type of arguments.
As per my lord, even the Rishikesh Das, my lord, this case, for this particular point, I'll showcase my lord, wherein my lord, the court had said, my lord, that if demonstratively, my lord, the petitioner is able to show that there is an error apparent on the face of record, my lord, and he backs it with cogent materials, then my lord, in a case of.
You did not have your pleadings on that basis.
It has, my lord, it has transpired through the additional affidavit, my lord, that I had, because they had kept us in the dark,
My
lord. They have
court
not-
master has also been confused with the fact that you are referring to a limitation act. And he has therefore produced before me a limitation act in respect to a service matter.
No, my lord, what I'm saying is that in limitation also, my lord.
No
they have given-
case. No, you have no case on the ground of delay.
One thing, my lord, consider, my lord, in the.
Show me one judgment where the Supreme Court says that, okay, forget about all these things, where it is gross illegality. The illegality is not so gross.
I will show it.
Show me.
Lordship, 802. 802. So my lord, what I'm on here is as paragraph 46, my lord. This is a division bench judgment, my lord, of the Rishikesh Das case, my lord. I would just like to highlight certain aspects, my lord. Page paragraph 46, my lord. So and so, my lord, further developed his argument by contending that paragraph 46 Kotiman, that the argument containing normal circumstances matters relating to examination, the court would not intervene. However, when the mistake or error committed by the examiner of the commission is demonstratively wrong, nothing would come in the way of the court to intervene. In this regard, my lord, the Honorable Senior Counsel has referred to the decision of so and so, my lord, at Uttar Pradesh Public Service Commission through its thing, my lord, and has drawn attention of this court to paragraph 12 and 13 of the decision, which are reproduced here in below. The law is well settled that onus is on the candidate to not only demonstrate that the key answer is incorrect, but also that it is the glaring mistake which is totally apparent, and no inferential process of or reasoning is required to show that the key answer is wrong. The constitutional court must exercise great restraint in such matters and should be reluctant to entertain plea challenging so and so of the key answers. In Kanpur University, so and so manner, the court recommended a system of so and so moderation, avoiding ambiguity from decisions to be taken to exclude suspected questions. Also. As far as the present case is concerned, even before publishing of the first list of key answers, the commission had got the key answers moderated by 2 experts. Thereafter, objections were invited and a recommendation of so and so manner. And then after that, my lord, the committee recommended that 5 questions be deleted in 2 questions, key answers be changed. It can be presumed that these committees consist of experts in various subjects for which the examinees or tested judges cannot take on the role of experts in academic matters unless the demonstrate the key answers are patently wrong on the face of it. The court cannot enter into the academic field. Accordingly, counsel submit that while the constitutional court is to exercise restraint in the matter of re-evaluation, however, where the error is glaring and demonstratively wrong and apparent, in which non-inferential process of reasoning is not required to show such an error, the court certainly can intervene, and the court can entertain the plea challenging the correctness of the answer. So in this case, my lord, a rule has been made, that is Rule 68A. That rule, my lord, has not been followed. They have given in on oath that it has been followed. Then, my lord,
Mr. Phukan, Mr. Phukan, I think I have not been able to convey to you what the court wants. You are not clear on what is to be given. If Assamese was the language of the court, I would have explained to you in Assamese. My simple question to you is, how do you take care of your delay in latches?
My lord, delay, my lord, I'll explain the delay then. That is the only way. I'll come to the petition then.
It can't be in the petition, Mr. Counsel, because 68A was not brought in the petition.
Because you-
That was not a pleaded case.
because you have kept it
So
down.
therefore, how do I help you? You see, you have to understand, Mr. Pukon, this person has been appointed in 2017. You wait. You don't do anything till 2022. 22 also, when you file the writ petition, you listen to me. You have any problem out there? Or ask her to argue this matter then. The matter, you see, in 2017, he has been appointed.
Right.
He has been doing his job. Now, on the basis of a thing which was not even a pleaded case, but improved subsequently on the basis of an order, on the basis of a statement made by them in the writ petition, in the affidavit, and this court inquiring into it. How do I help you? This is my specific question. I want to help you. But how do I help you? Because the moment I help you, there's no, I don't have the problem. It takes me 5 minutes out here to pass the order in your favor. But would you be able to sustain it in the division bench? Would you be able to sustain it in in the Supreme Court? Because obviously he is not going to let out so easily. But if you don't help me out with that, I cannot help you. Yes, there is a mistake committed by them. That 901, they should have properly followed 68A. But help me out. Or do you want that I should carry out the research? I hope now I have been more explicitly clear upon to you. And you must have understood what this court wants. Not these judgments, these judgments are not going to help you. Neither the judgment of the 2025, because these judgment which you are showing goes against you. Because here third party rights have been already created. There are many judgments on respect to service law where the court says that don't enter if there is a ground of delay. And they have specifically taken that point. Therefore, I said the APSC in fact helped you out. Yes, Mr. Monto, what is the judgments on delay and latches that this court should not entertain this type of writ petition?
These are the two, President, my lord, I think. Because it is 226, my lord. Ultimately 226, my lord. Of course, the first one is not in my lord service matter, but it is a tender matter, my lord. Like it, yes, le?
And this is land tender matter.
My
I'm
lord,
on the
that one
other one.
service matter. Second one is service matter, very short judgment, my lord. Para 6 is very important. The second judgment, my lord. It is 2022 SEC online 1800. No, I'm giving it because that is 226, my lord. Deed petition. Para, second one is my lord service matter, my lord. Para 6, my lord.
No. this is another aspect. This judgment which is of Sankar Mondal
My
is
lord.
on another aspect of the matter. That a person who was waiting out there, that his police verification did not come up, and after 7 years he
He
goes
didn't.
out there and files a writ petition that kindly give me this police verification. I have now got everything, and that. And the court said that recruitment process is already closed.
They
You
already
can't wake up after 7 years and do that. That is one thing. But you see, third party rights having
That's
been
already okay.
created, that is the biggest hurdle he has to overcome. Why there are no judgments? It would take 10 minutes to get this judgment out there.
Third party right to create mention it.
Yes, you. If you want to save your client's job, show me a judgment.
That in my lord, whether there is any pleading. His whole case is like my lord for re-evaluation of the question paper. It is not that my lord, there is no knowledge about 901 marks obtained by me and number 7. He has the knowledge.
Mr. Counsel, you have to appreciate one thing. It is not the case of the petitioner about 901. This case has been put by the APSC
Yes, my lord.
at paragraph number 8 and say that
10.
901 and we have given it to you because you have got more in the written examination. And say that we have followed rule 68 a year. And thereby he has now developed his case.
Yes, my. Now, before then, my lord, kindly see rule 67 also, my lord. Whether the selection was made only on the basis of merit or on preference. Whether there is a pleading in the writ petition, he has opted for the post of labor inspector.
Marks obtained in personnel shall be added to the marks obtained by the candidate. Thereafter, on the basis of the totals obtained in a merit list shall be prepared and placed before the commissioner here. How does Rule 67 help you?
My lord, preparation of a, my lord, fine. May I read, my lord? After completion of interview and select list, the marks obtained in the interview and personality test may be added to the marks obtained by the candidate in the written examination. Thereafter, on the basis of total mark obtained on merit list, shall be prepared and placed before the commission, my lord, by the principal examination of controller for preparation of select list. My lord, select list will be prepared how, my lord? What is the method? Select list will be prepared amongst the merit list from in the basis of preference, my lord, in order of preference. Suppose he has not given preference for the post of labor, he has not applied for that. This is a combined competitive exam, my lord. There are 6 services. Total number of posts is 124. Last line is important, my lord. Select list service oblique post wise, my lord. On the basis of order of preference given by the candidates. The select list has to be prepared on the basis of order of preference given by each candidate, my lord. Even in the advertisement itself is indicate, my lord. Because
Did you give a preference to labor inspector?
no statement, my lord, nothing is there in the pleading. His whole pleading is regarding the evaluation.
Apply first, because 64,
How?
might not taking into calculation the whole amount, it comes to 901.
No.
So after 90, if the aggregate is same, then my lord, after 67,
No.
68 comes. If the tally of the candidates, that is why immediately after 67, the total is taken of the written examination as well as the.
No, I'm asking you.
Preference for that,
Are you required to give a preference?
My lord,
Yes.
Yes.
But your preference, but my lord,
Yes.
what we have taken. I am not taking, I'm not for instruction regarding that, because that was not crucial. The main thing is, my lord, that the tally is sealed. If there is a tally of the written examination and the Viva voice. is
Oh, you have
sealed.
chosen 901 because of one thing.
68. A. When two or more candidates, right after 67, when 2 or more candidates secure equal aggregate marks.
Then why are you not asking for ALRS? What is this? ALRS, what is that job?
Assistant Registrar of Corporations,
Huh?
Assam Land and Revenue Service.
Assam Land and Revenue Service.
Yes. That was
Then
my second
S-
preference.
you are STP, na?
Both of us are STP.
Ah.
Passport number 8 also is.
So except labor inspector,
Yes, your lordship.
you have no other way.
No other.
So only labor
We-
inspector.
we,
But did you give a preference as regards that?
Yes, your lordship. We have, I think that we have not given him, but we have given preference labor inspector.
No, that will depend upon the preference asked for.
Yes.
But my lord, the rule 67 says that, my lord, that is different, my lord. The total is same.
No, no.
Of the Viva, my lord, as well as of the written examination. If the tally is same, that is why 68 has come in. my
Let
lord.
us see how the application will be made.
Yes, my lord. May I read? Kindly see, my lord, advertisement, page 25. This is important.
Very good.
May I read, my lord? Assam Public Service Commission hold preliminary examination of combined competitive exam for screening candidate for main examination for recruitment to the under-mentioned services, your lordship, public post, in accordance with the Assam Public Service Combined Competitive Examination rules. In that rules, my lord, method was already stated. Then, my lord, kindly see, my lord, page 26 and in the bottom. In the bottom, in the note, my lord, applicants are advised to submit only one application. For all these 6 services, one candidate has to submit only one application. That means, my lord, we have to give preference. It's indicate preference. Then, my lord, kindly see page 29. Page 29A, small a, my lord. How does the merit list will be prepared?
Where?
Page 29, my lord,
Ah.
written examination. The results of preliminary examination and number of candidates to be admitted to the written part of the main examination will be 11 to 12 times of the number of vacancy aforesaid. The selection will be strictly on the basis of merit adhering to the norms, vertical or horizontal reservation as per the prescribed rules. Rules is, my lord, 2089 rules for method of examination, procedure for examination. Then, my lord,
You are reading where?
page 29, my lord, advertisement.
Page 29 starts with optional subject.
No, my lord, 6 to, my lord, main examination.
Huh? 6 to main exam. The main
Yes.
examination consists of written and interview.
Yes, my lord. Now,
On the results of the year, the number of candidates shall be admitted in the so and so. The selection will be strictly on the basis of merit adhering to the norms of vertical and area. Will consist of the following papers of 3 papers.
yes.
Okay. Then
Then, my lord, page 30. Page 30B, my lord, D.
B.
Yes, my lord, B, interview.
Ah.
Kindly go to, my lord, straight away D. The marks scored in interviews will be added to the marks scored in the written part of the main examination, making the candidate will be determined on the basis of total marks of 10. Then next, my lord, E. Commission shall recommend exactly same number of candidates for different posts as notified. In labor inspector, my lord, for male, my lord, only 6 posts open is 6 or 3 posts are there.
No, candidates will be allotted cadre strictly
Yes, my lord.
on the
F.
basis of merit,
Come
preference
preference.
opted by the candidate in their applications for the main examination.
Yes, our merit both are getting, my lord, 901 marks, 9. Then, my lord, as per rules 67, the preference will see who will given the first preference to the post of labor inspector, who is given the second preference. The first preference will go ahead. That, my lord, 68 to my humble submission is applicable for determining rank after service, for determination of seniority. Then, my lord, next G is also important. Commission shall not recommend a candidate for the post who is he oblique she has not opted for.
Where?
My lord, same page 30.
A candidate for a
30.
post
G.
which he or she has not opted for.
Yes, my lord, there is 6 posts. If I have not applied for post service 1, so civil service, Assam civil services grade, junior grade, then I will not get appointments, though I reach the cutoff mark. There is no
And
pleading at
Mr.
all, my
Mohta,
lord.
what do you say on this aspect?
My lord, both
And-
the candidate given fourth option. So that is also equal, my lord.
Huh?
He is also giving fourth option, he is also giving fourth option. Labor inspector.
They have given options, same. So then your point goes.
Then, my lord, then my next argument will be, my lord, after confirmation of my service,
Third point.
after confirmation of my service, for the fault of my lord. Yes, my lord, the APSC is, your lordship is rightly say, APSC is always in favor of the petitioner. Now also it.
Point out before the court, my lord, the position.
My lord, after confirmation
You
of
had
service,
pointed
my
out,
lord,
you should have pointed out properly at that point of time in 2023 itself.
No, even then, my lord, it's too late, my lord. Your lordship kindly see this 2017.
So they have both. So your point, all these points, all
Suppose-
this happen out there because of you are not everything new things coming.
Yes.
Only point is delay in latches.
now, my lord,
There's no other point.
yes, my
There's
lord,
no other
af-
point.
after confirmation of
you
my-
want to save your client's job.
No.
You have to bring me a judgment on delay in latches.
now, my lord, my another
If
point,
he wants to save up his client's job, he wants his client to get a good job, then it can happen.
my another submission is that, my lord, after confirmation of my service, I have working more than now 8 years. It is now 8 years. My service was 2017, it was appointed. March 2017 or July, 18 July 2017. Thereafter, I worked for probation 2 years. Then thereafter, departmental examination was held in the 2022. I passed departmental exam 2023. July 2022, August, he approached. I passed examination in July 22. That was not under challenge. My lord, after confirmation of my service, whether I may be liable to be entitled to be terminated from the service. My lord, in this regard, my lord, there is a judgment. This one 2013-14 SSC, my lord. Here after appointment, my lord, the select list was revised. Then some of the candidates ousted. So court held that they have already continued for 2 years in service.
Which paragraph?
Yes, my lord, I'm looking for it. My lord, paragraph 28, my lord, can you see? The fact is that, my lord, they have already worked in probation for 2.5 years on the different cadre. Now, after, my lord, re-evaluation, the cadre has been changed. In our considered vote, the applicant has successfully undergone training and efficient to service the respondent state for more than 3 years. Undoubtedly, their termination would not be only impugn upon the economic security of the applicants and their defendants, but also adversely affect their careers. This would highly unjust and grossly unfair to the applicants who had innocent appointee of an errors of evaluation of answer script. However, their continuation in service was neither given any unfair advantage to the applicants nor cause undue prejudice to the candidates selected who are revised select list, revised merit list. Subsequently, the revised candidate who has got selected, they have been also appointed and they are also appointed. And
Mr. Counsel,
Lordship.
this judgment again.
My lord, there is also one judgment of the, but this is not reportable because it is not precedent. The Honorable Supreme Court held by Honorable Chief Justice. Oh, yeah, of third party rights.
Where, which paragraph?
Paragraph 28 onwards, my lord. Paragraph 24, 25 also, my lord. We find that appellants have caught in a peculiar situation acting on the order of, so he left his earlier job, now also be terminated from service. Both. Appellant cannot be penalized for the mistake committed by the
Sure.
Jharkhand
No,
staff selection.
I think I will dictate now.
Just one, my lord.
Your case, I'm dismissing it. No more.
Prayer 5, which I have given. Just for a saving this thing, my lord, prayer number 5 has given, has made also prayer for, to create a supernumerary post. If this kind of situation arises, my lord. Prayer number 5, my. In case.
Mr. Fukon, let me dismiss your case. The division bench also can't help you with that. You then go to Supreme Court. Supreme Court may exercise 142 and direct them to create a supernumerary post. This is a power under 142, not a power for this court. You see, directing, removing him and to direct you to be appointed, that is not it's very difficult. Only thing is, because the only problem is because you have come so late. Chalo, heard Mr. A. Fukon, the learned counsel appearing on behalf of the petitioner. Mr. T.J. Mohanto, the learned senior counsel assisted by so-and-so, appears on behalf of the Assam Public Service Commission. Miss so-and-so appears on behalf of the state of Assam. And Mr. So-and-so
get every-
appears for respondent number 8.
7 and 8, your lord.
7 and 8. Post. The petitioner herein is aggrieved by the appointment of the respondent number 7 and 8, by the selection and appointment of the respondent number 7 and 8 to the post of labor inspector pursuant to a combined competitive service examination held in the year 2015. It is under such circumstances the petitioner have sought for various reliefs in the writ petition. Full stop. The main reliefs which the petitioner have sought for, being relevant to for the purpose of proper disposal of the instant writ petition, are reproduced hereunder. It is 1, 2, 3, 4. Declaration 1, 2, 3, 4, 5, 5 6 Chalo. In the backdrop of the verb, let this court now deal with the facts which led to the filing of the instant writ petition. The Assam Public Service Commission, for short the APC, issued an advertisement bearing number 13/2015, dated 3/7/2015, inviting various candidates for recruitment to various posts in accordance with the Assam Public Service Combined Competitive Examination Rules 1989. Full stop. It is pertinent to take note of that it is pertinent to take note of the various posts which were advertised. It included the post of Assam Civil Service bracket junior grade, comma, Assam Land and Revenue Service bracket junior grade, comma, Assistant Register of Cooperative Societies, comma, Labor Inspector, Inspector of Taxes, and Inspector of Excise. From a perusal of the advertisement, it is apparent that the candidates who apply shall also give their preference in respect to the jobs, in respect to the posts. Full stop. The petitioner herein applied for the various posts, including the post of labor inspector, which was the fourth preference of the petitioner. Full stop. In the year 2017, more particularly, on 28/8/2017, the petitioner was informed upon filing an application under the Right to Information Act 2005 that the petitioner secured 901 marks in the combined competitive examination combined competitive main examination. Full stop. In this very communication which was issued by the State Public Information Officer of the Assam Public Service Commission of the APSC, the detailed marks so obtained by the petitioner against each subject were duly mentioned. Full stop. Be that as it may, the petitioner very well knew that he was not selected. In the year 2017 itself, and rather the respondent number 7 and 8 were appointed as labor inspectors. At this stage, it is very pertinent to take note of an interesting development during this period. What is the page number of this one, Rishikesh Das?
802.
Huh?
802. I think. 8. 46 minutes. That's right.
A candidate, namely Rishikesh Das, was aggrieved in not granting certain marks in various questions in the main examination, approached this court by filing a writ petition being WPC number 5576 of 2017. The learned coordinate bench of this court by their judgment and order dated 28/2018 allowed the said writ petition, thereby directing re-evaluation of the competitive examination paper and award of additional marks in respect to certain indisputably correct answers given by the said Rishikesh Das, for which no marks were awarded to by the examiner. It included the question. Which question, Mr.? Which question you are also,
Numerical 6, Roman D, Roman 5.
where is it here? He was only asking for 4 only. All questions are 4. Why are you asking for numerical 6?
Numerical 6, Roman D, Roman 5. That's a objective question. It's a page, my lord. Oh, my lord, Lakshmi is asking about the Rishikesh case. That, my lord, there, my lord, 900, 9.5 was about.
No, it's okay.
Huh.
But was
Question
one
was
of
different.
that question there? No.
All objective questions, and in that case, my lord,
Mr. Counsel,
my lord.
was this question which you are asking for re-evaluation, is there in the case of Rishikesh Das? No.
No.
No. Full stop.
Different paper.
Being aggrieved by the judgment and order dated 28/2018 passed in WPC number 5576/2017, the APSC preferred a writ appeal before the learned division bench of this court, which was registered and numbered as writ appeal number 61/2019. Full stop. The learned division bench of this court, by an elaborate judgment, dismissed the said writ appeal, thereby confirming the judgment of the learned coordinate bench dated 28/2018 by the elaborate judgment dated 7/10/2021 day. Dismissed the writ appeal and confirmed the judgment of the learned single judge, the learned coordinate bench.
That case, my lord, your lordship can say last two para, my lord, because in that case, my lord, there is a
So,
complete.
Don't worry, don't worry. Pusto. An appeal thereagainst was preferred by the APSC before the Supreme Court. And the said appeal and the Supreme Court rejected the said special leave petition
Important light now.
by keeping the question of law open. An appeal being special leave to appeal C number 2946/2022 was preferred by the Assam APSC before the Supreme Court. And the Supreme Court, by an order dated 28/2/2022, rejected the said special leave petition, keeping the question of law open, dismissed the said. The dismissal of the special leave petition by the Supreme Court in the order dated 28/2/2022 encouraged the petitioner herein to approach this court to file a writ petition on 12/8, file the present writ petition on 12/8/2022. In spite of the fact that the petitioner had due knowledge that the respondent number 7 and 8 were selected, recommended, and appointed as far back in the year 2017. First, the petitioner herein have filed the instant writ petition primarily on three grounds. First, the petitioner sought evaluation in respect to the question number 65.
Roman numerical 6, Roman D, Roman 5.
Numerical 6, Roman D,
Roman 5
Roman 5,
of the general English paper.
the general English paper. Re-evaluation of question number so and so. Which one? 6 D Roman 5. I did not feel very well yesterday, but I feel better today. I felt better.
Feeling.
This one. Though the petitioner received the question paper, the answer script in the year 2017 itself. The second ground is that there was a illegality committed by the examiner while awarding marks to the petitioner in terms with Rule 56 of the Assam Public Service Commission bracket Procedure and Conduct of Business bracket close Rules 2010, for short the Rules of 2010. It was the specific case of the petitioner that this particular rule mandated that no marks should be overwritten and marks should be given clearly and legibly. And if necessary, it may be cut by a line across it, and the new mark allotted may be written over it by putting signature. It is the case of the petitioner on the basis of the answer script which the petitioner received as far back as in the year 2017, that while awarding the marks, there was overwritten and it was also there was overwriting and also there was no signature put. Primarily on these two grounds, the present writ petition was filed on 12/8/2022. First off. The respondents, APSC, filed the affidavit on 25/8/2023. The filing of the affidavit, and more particularly the contents of paragraph number 8 of the said affidavit in opposition, led to the third ground on which the petitioner has attacked the selection, recommendation, and appointment of the respondent number 8. The ground is that there was violation of Rule 68 of the Rules of 2010, inasmuch as both the petitioner and the respondent number 8 secured 901 marks, but as the petitioner secured more marks, which the petitioner came to learn subsequent to a further affidavit being filed by the APSC, in the main subjects, the petitioner ought to have been chosen, ought to have been selected, recommended, and appointed, other than the respondent number 8. First, this court have duly taken note of. Now, in the backdrop of the above premises, let this court now deal with the respective contentions raised by the parties. Mr. A. Phukon, the learned counsel appearing on behalf of the petitioner, submitted that not granting of marks in respect to the question 6D Roman 5 was a mistake or error committed by the examiner of the commission, which is apparent. And as such, if these 2 marks is given, then the petitioner marks would be 903 and thereby the petitioner can be selected, recommended, and appointed against the post of labor inspector. The learned counsel for the petitioner further submitted that Rule 56 of the rules of 2010 has been violated, and in that regard referred to the tabulation of the marks given to the petitioner which is at page 50 of the writ petition. The learned counsel submitted that the petitioner initially was given 200 marks, which was struck off and made 198, which was again struck off and then given 196, but there is no signature, which therefore violates Rule 56 of the rules of 2010. First, the learned counsel for the petitioner further submitted that a perusal of Rule 68 of the rules of 2010 would make it apparently clear that in case of a tie, the candidate who have secured more marks in the main subjects would be given preference. First, the learned counsel, appearing on behalf of the petitioner, drew the attention of this court to the affidavit filed by the Assam Public Service Commission, by the APSC, on 14 on 7/1/2026, and more particularly to paragraph number 2, wherein it would be seen that the petitioner secured more marks in the general studies and general English combined together to that of the respondent number 8. The learned counsels, therefore, the learned counsel appearing on behalf of the petitioner, further referring to the Assam Public Service Combined Competitive Examination Rules 1989, referred to Rule 2, referred to Clause 2 of Appendix 1, and submitted that which would be the main subjects. First, he therefore submitted that Rule 68 having been violated, he therefore submitted that if Rule 68 would have been applied, then in that case, the petitioner would have been selected, recommended, and ought to have been appointed to the post of labor inspector. Anything more?
If, he would have scored 58 marks more. 58 marks more.
Huh?
No, it's fine.
What 58?
No, he would have had the tally been done as per 68A, then my score would have been 58 marks more than me.
No, that is not necessary. That is what it is there. Let the division bench make this calculation. Okay, let me come back. Your submission, Mr. Mohanto's submission. is completely baseless. And it should be dismissed on the ground of delay and laches. The learned senior counsel submitted that the respondent number 8, that the instant writ petition has been filed merely on the basis of apprehensions, merely on the basis of have been filed. Seeking a roving inquiry, fishing and roving inquiry. Pusto. Referring to the judgment of the learned division bench of this court in the case of APSC versus Rishikesh Das, reported in 2021 4 GLT 788, the learned senior counsel submitted that the said candidate Rishikesh Das immediately approached the court in the year 2017 itself and certain interim directions were passed then. However, in the instant case, the petitioner was a fence sitter and awaited the outcome of the judgment in the case of Rishikesh Das Supra, which was confirmed by the Supreme Court. On 28/2/2022 and approached this court on 12/8/2022. The explanation of delay which have been mentioned as regards COVID pandemic and all does not apply at all, taking into account that these appointments were made much prior to the COVID pandemic have ever set in. The learned counsel further submitted that the petitioner had all the materials available as far back as on 10/12/2017 itself. And the petitioner sought to approach this court almost after 5 years. In the meantime, it is further submitted by the learned counsel, senior counsel, that the respondent number 7 and 8 were duly appointed in the year 2017. And subsequent to certain departmental examination, they have also been confirmed as far back as in the year 2023 itself. He therefore submitted that the petitioner, that the instant writ petition ought to be dismissed purely on the ground of delay and laches. The learned senior counsel, however, with all fairness, submitted that there was a mistake in applying Rule 68 of the rules of 2010. But in the present facts and circumstances, this court may not exercise its extraordinary jurisdiction. Anything more?
Regarding delay point, my lord, and in the CC case, das case, my lord, there is promptly approach, my lord, and there is a stay
I
order.
said
Yes,
that.
that's
Anything more?
that. And 19th April, no, 19th. All right, man, that is that regarding, my lord, a revaluation, my lord. The rule does not permit in the section, rule 17, my lord, I have affidavit, I have clearly mentioned, my lord. Regarding revaluation does not permit, my lord. And regarding signature, there is a signature in the, so far 68 is concerned, my lord.
56.
56 is concerned, my lord. There is a initial signature is there, my lord. In the mark sheet, my lord. That is, I have replied in my affidavit, my lord. There is a calculation error, probably that is why, my lord.
The signature should have been,
Yes, signature is there, my lord.
the bottom part, there is no signature. Should have been there as per rules.
The learned counsel, senior counsel further submitted
My affidavit, my lord.
that a question of re-evaluation is not permitted as per the rules of 2010 itself,
Yes, rule
Yes.
70,
as per Rule 17 of the rules of 2010.
70.
Huh?
Rule
17.
70.
70. And further, there is no infraction to Rule 56 of the rules of 2010 in as much as there is a signature
My lord, no,
against
duly signed. That is my
signature
submission.
duly appears.
ওপর লেখা আছে, দেখেন আমি। তার signature নেই। তার আছে না।
Page 50, the above part where they have crossed it, there is a signature, but the bottom part there is.
Aha,
That is my submission.
that is his submission. The learned counsel further referred to the judgments of the Supreme Court in the case of Mrinmoy Mehti versus Chanda Kole and others reported in 2024, 15 SCC 215, as well as another judgment of the Supreme Court in the case of Sankar Mondal versus State of West Bengal and others reported in 2022 SCC Online SC 1800. Mr. So-and-so, the learned counsel who appears on behalf of the respondent number 8, 7 and 8 submitted that insofar as regards respondent number 7, the petitioner has no case at all, taking into account that the petitioner, respondent number 7, had secured 907 marks. And even if there is a re-evaluation ordered, then also it would not affect the selection, recommendation, and appointment of the respondent number 7. As regards to respondent number 8, the learned counsel submitted that the question of re-evaluation is not permitted as per Rule 70 of the rules of 2010. However, 2010, full stop. The learned counsel further submitted that the principle of law laid down by the learned division bench of this court in the case of Rishikesh Das Supra cannot also be applied to the facts of the instant case, taking into account that the petitioner has approached this court after 5 years seeking re-evaluation in respect to question number 6, Roman 5, bracket D, bracket D, Roman 5. The learned counsel appearing on behalf of the respondent number 7 and 8 further referred to the judgment of the Supreme Court in the case of State of Madhya Pradesh versus Nandlal Jaiswal, reported in 1986, 4 SCC 566, and submitted that as third party rights have already been created by the appointment of the respondent number 7 and 8 as far back as on the year 2017. And the respondent number 7 and 8 in the meantime have also been confirmed. Any exercise of the jurisdiction in the present case may have the effect of inflicting not only hardship and inconvenience, but also injustice on third parties. The learned counsel next. Mr. A. Pukon, the learned counsel appearing on behalf of the petitioner, however, replying to the allegation of delay and laches, submitted that if the illegality is apparent, the petitioner cannot be ousted on the ground of delay and laches. And in that regard, had referred to a judgment of the Supreme Court in the case of Ram Otar Singh Yadav versus State of Uttar Pradesh and others, delivered on. This is not reported. It must be there in SSC online. A judgment of the Supreme Court dated 4th of December 2024, rendered in the case of Ram Otar Singh Yadav versus AUTAR versus the State of Uttar Pradesh and others. And referred to paragraph number 20 of the said judgment. Isn't it? Analysis and
Paragraph 20.
determination and paragraph
20, my lord.
22.
20, my lord, 20 regarding that part only.
Paragraph 20 and
22.
22.
20, my number of factors need to be considered before a petition is dismissed on the sole ground of delay in nature, that part. And my lord, I rely on the intesting also. Intesting, para 14. Intesting, para 14.
he further referred to the judgment of the Supreme Court in the case of
Intesting,
Inder Singh versus the state of Madhya Pradesh reported in
2020 SCC 680.
huh?
2020. On top metal, see 2020 20 SC.
No, you are referring to Inder Singh, na?
Oh, sorry, read it. Index.
Inder Singh versus state of Madhya Pradesh reported in what to say?
In light blue.
This is Supreme Today you are giving me.
Why not? It is paragraph 14. I will write. Paragraph 14.
Reported in 2025 INSC 382 and referred to paragraph number 14. Full stop. Analysis and determination and analysis and determination. Full stop. This court have duly heard the learned counsels appearing on behalf of the parties and have perused the materials on records, the respective pleadings, as well as the judgments which have been relied upon by the learned counsels appearing on behalf of the parties. First, in the foregoing paragraphs of the instant judgment, this court have referred to that the petitioner had sought for three grounds, have the case of the petitioner hinges upon the three grounds. First, the question, however, arises taking into account the submissions so made by the counsels appearing on behalf of the respondents is as to whether this court at this stage should entertain the instant writ petition, taking into account that the petitioner have approached this court after a delay of almost 5 years. First, the materials on record, more particularly, the Annexure 4 series, where the Annexure 5, Annexure 4 series. Would show that on 28/8/2017, the petitioner was informed about the marks which he has obtained in the combined competitive main examination 2015 against each subject. Thereupon, the petitioner submitted the challans and were provided with all other documents which forms a part of Annexure 4 series. In the year 2017 itself. The petitioner thereupon remains silent. And only on 12/8/2022 filed the present writ petition thereupon remains silent till submission of a representation on 27/9/2019 seeking granting of awarding 2 more marks on the question being on the question number 6D5. The petitioner thereupon again did not take any steps till filing of the writ petition in the year on 12/8/2022. It is very pertinent to take note of that in the meantime, both the respondent number 7 and 8 were appointed in the year 2017. And subsequently, after they have also been confirmed.
€157.
After passing the departmental examination in the year 2020. This court now finds it pertinent to take note of the observations made by the Supreme Court in the case of Nandla Jaiswal. And in that regard, this court reproduces paragraph number 24. Nandal, this was Supra, huh? A perusal of the above quoted paragraph would show that when there is unexplained delay coupled with the creation of third-party rights in the meanwhile. It acts as an important factor in deciding whether to exercise such jurisdiction or not. In the instant case, it would be seen that not only third-party rights were created as far back as in the year 2017, and subsequently, both the respondent number 7 and 8 have participated in the departmental examination and have also been confirmed. But the delay explanation so given does not convince this court to be a reasonable explanation. The learned counsel appearing on behalf of the petitioner had relied upon the judgment of the Supreme Court in the case of Ram Authar Singh Yadav. Which, in the opinion of this court, would not aid the case of the petitioner. Inasmuch as, in that case, neither there was any accrual of any parallel right of third party, nor grant of relief would cause confusion and public inconvenience. In this regard, this court finds it pertinent to take note of paragraph number 21 of the said judgment, which, in the opinion of this court, squarely applies to the facts of the instant case. Full stop. This court have also taken note of that the rules of 2010 do not permit re-evaluation. Full stop. The judgment in the case of Rishikesh Das, Supra, and the observations made therein, in the opinion of this court, cannot be applied to the facts of the instant case, taking into account that the said applicant, namely Rishikesh Das, had approached this court promptly in the year 2017 itself, unlike the petitioner who approached after 5 years. Considering the above, this court therefore is not inclined to exercise the jurisdiction under Article 226 of the Constitution, even though there is an apparent irregularity in applying Rule 68 of the rules of 2010. Accordingly, the instant writ petition stands dismissed with cost imposed. No cost? Cost will help you in going to the division bench and getting a stay for some time. Sure. Ready.
Apply, sir.
No cost, huh? Yes, what is this? R.S. Deori. Oh, yes. Appearing on your submits that she has not been able to procure the order by which the, oh, you got it. Is this the order? Okay. Wait. You do one thing. You withdraw with liberty, challenge this order. Huh? I acted as a public information officer for getting this. Okay. Pursuant to the order passed by this court on 5/1/2026, Mr. N.R. Sharma, the learned counsel appearing on behalf of the respondent number 3 to 6, have produced a copy of the appointment order dated 24/4/2025, whereby the respondent number 7 was appointed as Anganwadi worker / Anganwadi helper to N/Dotma AWC number 58. Pustak. The copy of the order is kept on record and marked with the letter X. Ms. R.H. Deori, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would be well advised to withdraw the instant writ petition with the liberty to refile by challenging the office order dated 24/4/2025. Pustak. Taking into account the above, the instant writ petition therefore stands closed on withdrawal. Pustak. Liberty is given to the petitioner to refile by challenging the order dated 24/4/2025. You've got a copy, na?
My lord, I'm appearing for 1 and 2 minutes.
So and so appears for you.
For admission item 6.
এই তাতে এটা লিখি দিবা, copy of the order, a copy of the document kept on record and marked with the letter X was handed over to Miss R.S. Deori during the course of the day. FA Law School, what is this matter? Issue notice. What is this application? Compassionate?
Yes, Lordship.
Ah, dismiss ko dibo. When did the father die?
2013.
Father or mother died?
13, Lordship.
Huh?
13,
13, na?
2013.
And he filed the application in 13. A2 side play dismiss kori dibo. None appears for so and so, Aria, she appears for this. A2 kori play, A2 mur juntu ata ase, juntu clause, A2, আজি 2013 or application, and আজি dito jibu nohobo boli. Akhon ase no, compassionate eta ase. Jot hol is an exception to the Article 16 and as such, it has to meet with all the points, and 2013 or application was ruled as per 1/6/2015.
Lordship.
They will be regulated by which one?
The earlier one, Lordship, 2009.
2009, na?
Yes, Lordship.
So 9 is already there. 2013 dismissed.
And the poster also of not that time, Lordship, of when the DLC considered Lordship, posts are of 2020, 2021, 22 like this, Lordship.
No, this is 2013. If person can remain out there, no.
For hearing item 11.
Any development? Who is paying for? Where is Mr. Dinath?
Lordship, I'm just following.
Item number 6.
What is 6? Which I dismissed just now. 6. I'm dismissed. Your name, you want to put your name out there.
No, madam. My sir in 4 year over 4. He is at hospital.
So you take the dismissal in your name? Man, dismissed. 2013, what is there?
May I please your lordship, lordship kindly allow, lordship may kindly allow, 2 minutes, the,
Which one?
I'm, UFM DL, item 11,
11.
yes,
We'll take it after some time. Ask Mr. Dinath to come.
okay.
12.
What is this, 6?
I don't know about the paperwork, but my seniors over telephone bill, it is allowed.
No, no, you are not there also. Dismissed. What do you want? A dismiss for default or a dismiss on merit?
Yeah, I wanted adjournment.
No, no. This type of cases can't remain for long. Unnecessary.
Next week, my lord. Next week.
What?
Next week, please.
No, no, this case can't come. Okay, item number 6, Koiba. The council is appearing on behalf of the petitioner and is not interested in doing the matter today. So taking into account the above, list the matter after 6 weeks.
Item 12 for hearing.
Because judgment to আপনার আছে না এটো? Okay. None appears on behalf of the petitioner and respondent. Accordingly, matter stands adjourned to be listed after 4 weeks. After 3 weeks, and data the due.
Third,
FCI. What is this?
item 13 and 14 for hearing.
Two 2014 matter, this matter needs to be finished. Seventeen two. One attacking 17. What do you Hello. None appears for the petitioner on call.
Item 15.
Now this is,
No, 13, 14.
okay, Mr. Dinath, you have come. What has happened to that 11?
But I have received the instructions. They said after the Industrial Relations Code of 2020, the amendment of rules have now, it has become, they said null and void.
So then it is not necessary.
It's not necessary.
So now you don't require, this has
Lordship,
already come in.
Lordship.
So therefore we now take up his on merits.
Lordship, Lordship.
This content not be correct. So far the Industrial Standing Order Act is concerned, it has not been fully repealed.
They said that they will go for preparation of this.
Standing order.
Put up, replace, they will maintain the money. On the way. Then we do one thing, let's see the Code of Wages Act, no? What Code of Wages?
Where is the code of the look like?
Because I only kept this matter because of this thing. Otherwise, the on merits I can deal with it.
Yes, yes, that can be right.
Yes.
Can be done.
Yes, the merits on merits is
Because
the
it
only,
was not-
I still remember your case is, at that point of time, there was no, no, it is the case of Mr. S. Das. S. Das was appearing on the other side, if I'm not wrong.
Our case is that there are, though there is a standing order, but in the standing order, retirement age was not mentioned.
Ah.
So as per the presiding officer, that as there is no retirement age, if a person can work, he should work. If he, and so he was allowed to work even at the age of 71. That was the.
You know, your case is that he was 71, 71, 72. But their case is, he was around 45 or 50.
58.
Yeah, 58. So at that point of time, it is there. So it was a termination. Your case is that it was a case of release on superannuation. But how, if there is no rule out there, how do you say about the superannuation? It can be a release.
Council of Care, section 104
Of
of this code.
Code of Wages.
Industrial Relations Code 2020.
এখন কি দিলে মুখে হয়? Code of Wages Act 2019. We have only. These actually did not, did they subsume Code of Wages Act?
So it will be covered by the Industrial Relations Code 2020.
এখন আসুন।
Industrial Relations Code.
Let me have a look at it.
First November 2025.
Yes, which section?
104. In the notification,
In a notification issued under the the central government may specify that the provisions of yes then shall repeat with effect from the date of appointment in the notification. of Iman and remaining provision in neck pen dispute referred to in the clauses A to C shall remain until they are. Now, has any notification come under 104?
Some 25 we are like this, I think. 21st November 2025. Sir. Otherwise, this standing order will be applicable in an establishment where more than 300 workers are working.
Hmm.
You do the defines now.
Section 104 of the code, Malab, it says that the Industrial Employment Standing Order Act 1946 is repealed. Notification does say. Government notice. Implementation gazette to sir. Gazette to sir. Gazette to sir.
Do I get the notification of 2020? So establishment as per the formation of the committees and union, industrial establishment with 100 or more workers or have been employed on any day in the preceding 12 months.
Normally, section 28 of this act incorporates those provisions. But only difference is that it has been made applicable only with respect to the establishment where more than 300 workers are built nowadays. Not that the standing order act has been repealed totally.
46 rules have been repealed. 46, 1946 Standing Orders Act has been repealed.
No, actually, it's a, come to section 104.
Now, 104 says that you can save something.
No,
got
here,
it. In exercise of the year, Central hereby appoints the year as the date on which the applicable provisions of this code shall come into force. But they did not, the central government did not touch on this, anything saving or a year. In the notification under 3 of subsection for the commencement of any provision, the central may specify that the provisions of so and so shall then repealed with effect from the date of appointment, notwithstanding such repeal under anything done under so and so, without prejudice to remand the provisions of section here shall apply to the repeal of such enactment. So now,
So far, after clause C, shall stand repealed with effect from the date of date appointed in this notification in this behalf, and remaining provisions of the enactments referred in clauses A to C shall remain force till they are repealed by like notification in like manner.
but how do you take care of this? In the notification issued under subsection 1(3), this is the notification,
Subsection 1(3)
1(3).
of section 1.
For commencement of any provision of this code, the central government may specify that the provisions of so and so shall stand repealed with effect from the
Yes,
date
they
of
specify.
appointed in the notification. But
So-
the central government did not specify anything.
Indeed. Please. What is?
Huh? Because did you?
Yes.
This is the notification. It doesn't say anything. Have a look at it.
On this simply in exercise of power conferred such and such, the central government hereby appoint 21st day of November 2025 as the date on which the provisions of the said code shall came into force.
Somehow I'm not getting that notification anywhere.
Now, moreover, if you are to go through section 28, it will make clear. The provisions of the standing order detail.
Got it. In history, the government of India has announced that the 4 labor codes so and so, so and so, so and so, so and so, rational 29 so and so, by modernizing so and so, many of the mandatory appointment formalization, so and so, benefits of labor, contract, women, MSME, so and so. Okay, now,
Government may specify.
no, it's okay. Then we do one thing, Mr. Dasgupta. As the government, why should I now deal with that issue? Earlier, it's okay. I think now we take it up, your case on merits, better off. Because we asked them earlier, but now as it is their stand, that it is not necessary, then I think why should this court go into that?
But if it is there, then probably it will create some problem in future cases. their main understanding is that the standing order is not applicable. What happened here, your lordship may, let us take the risk of the control provisions 28 of this act. Here, chapter 4. Got it?
This is for standing orders.
Mhm.
Only standing orders is only where there are more than 300.
300 workers are. Otherwise, all everything, sir, yeah. The draft preparation of draft standing order, certification of the standing order, as it is, earlier act. If I take the comparison.
For those who are less than 300, it shall not apply.
Exactly. As per this act. Otherwise, will be applicable. Only thing the earlier act, they have incorporated certain provisions of the earlier act under section 28, 29, 30.
So now the state has no power. No power. See, 31, 29.
Making of body standing order.
So it is only by the central government. Where is the state government has the power? No power. No power.
Not noticing anything contained in the treaty.
State government would have be the appropriate government for some for giving some exemption. Isn't it? In relation to industrial undertaking carried out or by under the authority of the central government or concerning any of the control of so and so in any one with the central government. In relation to other industrial, including state public undertakings, subsidiary companies set up by the municipal and autonomous bodies owned or controlled by the state government, the state provided that in case of dispute between a contractor and contract labor employed through the contractor
as it
in
is
an
also.
industrial way such dispute first road, the appropriate government shall be the central government or the state government as the case may be, which is controlled. Okay. So only exemption is there. Now the state doesn't have the power as regards the standing orders.
So far appropriate government definitely is concerned,
Ah.
section 2B.
That is what, no, they only have, the appropriate government only has the power to exempt as per 39. But the appropriate government, but the interpretation of the standing order, these
The appropriate government.
only power to make the standing orders is of the central government now. Not even the appropriate government. Isn't it?
The appropriate government may by notification exempt conditionally or unconditionally any industrial establishment or class of industrial establishments from any or any of the provisions of this chapter.
So they can exempt. Exemption is different from making the standing orders. Now what we were trying to say, that kindly make kindly make the standing orders. Now, as of now, this act has come into being.
21st November.
It has come. Now, with this, any standing order is to be made is by them. They can't keep on allowing the Industry 46 Act to prevail. Because it will have a difficult situation then. So we do one thing. We need not go on now with that. We take up the matter on merits. When do you want?
Not there, but tomorrow.
22nd would be a motion day. Taking into account the courts are mostly closed nowadays. Last 1 month, we have only work for 5 days.
Candidate, your lordship, submit your lordship convenience. My case is simple.
No, your case, I know, I remember. Although
Now-
I
now
was
if you-
taking it up.
If your
Although
lordship allows
last
to go
time,
in this way, then my case will be very simple.
your matter, I came up, I heard this matter last time in 2023. The issue, I have framed it on 10/8/2023. In absence, in the certified standing order stipulating the age of retirement of the workman, what would be the age of retirement in private industries in the state of Assam? Whether the Assam Industrial Employment Standing Orders Amendment draft rules have been brought into force, and whether Schedule 1 of central government would prevail in absence of the standing orders or the government of India of Assam regulating the age of retirement. That's all. So
The order was
here
passed
the
in the
only
year
issue
20.
is this. So I think we need to complete it as soon as possible. We have it, this is 2011. Let's take it as the first item on Thursday. Thursday you are there? Or next Tuesday? Next Tuesday is bit difficult. 29th? 29 as the first item. We finish it off then. Okay. Heard Mr. A. Dasgupta, the learned senior counsel, assisted by Mr. B. Prasad, who appears on behalf of the petitioner. None has appeared on, you are appearing? So and so appears on behalf of the respondent. Number 2. Full stop. Mr. Dina, the learned senior government advocate, have placed before this court an instruction dated 1/12/2025, wherein it has been mentioned that in view of the notification dated 21/11/2025, whereby the Industrial Relations Code 2020 has been brought into force, the question of the full stop. Oh, yeah. The question of further pursuing with the Assam Industrial Employment Standing Orders Amendment Rules 2025 do not arise. In that regard, he has placed an instruction before this court, which is kept on record and marked with a letter. Letter submitted in a flag A-B-C-A1, 8B1. Full stop. In that view of the matter, this court now would be taking up the instant writ petition on merits on the issues which were formulated on 10/8/2023. Full stop. Taking into account that the instant writ petition is more than a decade old, list this matter for final disposal on 29/1/2026 at the top of the list.
What this confusion is done by the bigger document. I have
No, it is his submission. I'm not taking it up. Let us not go into that. Yes, what happened? You were not there.
Can be taken up at.
No, no,
Next set.
no, nothing.
It's a pilot for a long time. Earlier also-
Release from Pathak Koidi.
Earlier also judgment.
Absolutely no. I fix it to you. Both of you were not present when the matter was called. So therefore,
It did not say when the for the time being.
I waited for 5 minutes. None of you were present. And you can,
Don't delay it. Already your lordship has, most of the part judgment has been ordered. So, any day, the 7 17th of February, let it be, because otherwise. I would
Little bit 17. I am ready with the records today also. I have it.
Today also he is happy.
Yeah, it has everything. Because only that part is to be looked into whether those documents were there in the record or not. It is there. Both set is there. One is prior to March, then post March.
No, you see, Mr. Ikea, you have to admit one thing. You see, I have to first give more importance to bench three matters because I'm taking up the bench three matters. There are more old matters than your matters. No, you have to understand. If you miss your chance out there when the matter is being called, then I think we should be. 10:30, what should I do? Because there was another matter which was there at a year. You are busy out there, so you do it some other day. So I have to fix it on 17. No? এই ইয়াৰ জাজমেণ্টটো আধা মাৰা হৈছে নহয় সেইখিনি মোক দি দিবচোন because these days next week there is no time then we can have it on 7th 7th you are doing it 7th it's a Saturday 7th
I have to come.
7th এইটো 7 কৰি দিব পাতত 7th তাৰ আগতে মোক এইটো দি দিব উইল ফিনিশ ইট
As per last order, Lordship, I have deposited the cost, Lordship, and received the records, Lordship.
Okay, Mr. Argue now.
Yes. Basically, we are facing 2 points. One is the rationality. This fiscal measures, my lord, it's difficult to challenge. But there must be, your lordship also appreciate that there must be a rationale. Now, lordship, what the increment is our first point. Which ranges up to 197% to 600-300%. Let me refer in para 14 of our PPT. We just set out some examples wherein our holding earlier rate, there must be some increasement, definitely, long before it was fixed.
No, when was the last it was done?
In 1975,
Then-
subject to correction. And
Yes.
that's I
No, if it is, if you have a case within the ambit of any violation of the manner in which it has been done, then it is a different.
Lordship may consider that aspect also. Whether it's a ratio.
It's very difficult for this court now to look into the rationality. Means the increase which has happened. Like word number 3, it was 1597, it has now become 12,686. This increase happened in 2019.
Right.
19. Okay. So this is after 19 plus another 25 years, it's around 44 years. It's okay. You also have to see the inflation in the meantime, which has increased.
Based on second point,
1975 rupees 1 value
that is
as of now would be how much?
the value is gone.
Yes,
Yes,
as per,
75 with 100 rupees, will get a full bucket of everything market.
as per
The
our,
value of the land at that point of time and now has increased many folds.
Second point, one thing is not, where I think we have noticed, that the measurement of the land, they have mechanically increased. how it's been done. Suppose it's 100 square feet there. Now that's into 1.5. It's enhanced to 1.5%. That also invites some serious question. How it could be? What are the parameter of multiplied it by 1.5?
No, your argument on 3/11/2025
No,
was
that,
different.
okay, I will come to that.
So you
So
come
for
on
the-
this.
So for the enhancement of tax is concerned, I have to these two submission. Second, my lord, that they have highlighted the 79 with the, on the last occasion.
Yes, come to that point only,
Yeah.
that I think.
So therefore, in that.
That the
lordship is
powers under
examined by
section
the-
79C and
Yes.
79D can be
Yes.
exercised by the respondent authorities provided approval is taken from the committee constituted in terms with 79A5 of the Assam Municipal Control Act. The learned senior counsel referring to the notification dated issued by the commissioner so and so had submitted that in terms with the said notification, a committee was duly constituted. However, neither there is any material on record nor any stand is taken by the respondent's authority. The revisions so made by the refixation of the annual rental value of the holdings have been done with the prior approval of the committee so constituted. Further submitted that in terms with section 68 of as well as so and so, the concept of urban tax is foreign to the Act of Iman. However, by the impugned notification, in addition to the holding tax, the urban tax have been imposed by so and so. The learned senior counsel therefore submitted that the impugned notification is contrary to the provision of 79C and 79D. And further, the imposition of urban tax is ultra vires the provisions. So let's confine yourself to those arguments.
That's why the second submission.
That is the main only submission. Let's not go into that.
Says everything may not apply.
Now, let us come to 79. Now, let's see the impugned notification.
Yes. Final notification is stays 36.
In pursuance to the government's notification, the holding tax upon Iman has been reassessed and a new reassessed holding tax will be effective from Iman as per the new rates. The new rates shall remain valid for a period of 5 years. The draft reassessment was published on so and so. A board meeting was held on so and so under the chairmanship of the chairman so and so to discuss and adopt a resolution to reassess the holding.
What you will find that the board has decided everything. Not the constituted as per the section 3 subsequent 5. The entire thing has been decided by the board.
Why do you say so? Let's see the section.
Yes. Okay. 79.5.
79?
79. A5.
Subject to the approval of the following committee, as municipality may from time to time publish the list of principal main roads and main road and if necessary modify the list as may be.
Here,
Yes, what is this?
so these comments. So therefore, my lord, is find in the final assessment on perusal of it is appear that everything has been decided by the municipal board in their meeting. It has to be decided by the board. Committee, that committee has constituted on subsequent 5. That has to be examined by the council, whether that has been the legal, this precondition has been fulfilled. And the urban tax. and 79D.
Now 79C says power to fix the rental value and annual rental value.
Yes.
79B says the method of calculation of the carpet area for
Yes,
computation
yes.
of the annual rent.
Holding tax,
Huh?
they also keep the holding tax. Here there's 4 type of tax. 79D.
79?
B.
Holding water,
Holding
latrine
water
tax.
and latrine, all these 3 tax. Now holding water and latrine will not come. Because that has to be subject to section 71 and 72. Madam. It has to be supplied then only. So holding will come, but there would be no concept of any urban tax as per the municipal act. So
Where's
they
the,
impose
where's the urban tax?
urban tax, Lordship will find page
For
36.
both residential and
Fine.
commercial establishments, rate of holding tax is 3% and urban tax is 3%.
Yes.
Hence, total property tax shall be fixed at 6%.
That
Holding tax plus urban tax.
holding that 3% is in the section 79D. Yeah, under the municipal act, there is no concept of any urban.
So
The
you have,
holding is itself urban because in the municipal, in the panchayat, there is no question of any holding.
a constitution consult.
In 76, 77 Lordship, they are paying the urban tax also. At that point of time also, they are paying the urban tax.
Maybe, but then also tax is on the basis of an authority by law.
Yes.
Isn't it Article 268? What does it say? 268. Duties levied by the union but collected here 268. Not to be imposed, say by no tax shall be levied or 265 levied or collected except by authority of law. So which is the law for urban tax?
That was not their Lordship, but we have collected because it was collected earlier, it was 14, all along 14%. Now it's come down to 6%.
Which one?
The entire tax. Earlier it was 14%. Now it come down, we have come down, make it up to 6%. 3% holding tax and 3% urban tax. Earlier it was 14% tax. Now,
Of the holding tax.
yes, Your Lordship. Now it come down to 6% as of
But
our,
then also,
the concept
unless
of
you say
Lordship.
that the urban tax and holding tax is one and the same, it's a different thing.
Lordship.
But where do you bring in the urban tax?
That was
Unless by
not,
authority
that
of
was
law.
nowhere clear from this records, Lordship, because urban tax, as we are collecting earlier in 1970, my instruction, Lordship, 74, 70, in the year 74, 76, there was the urban tax. So it comes from there, Lordship. They are taking that urban tax. It was not that it was imposed in this year only.
I'm not on that, Mr.
I understand,
Counsel,
Lordship.
but the problem arises is there is a constitutional mandate.
Yes, Your Lordship.
Which says that taxes not to be imposed save by authority of law.
Yes.
So therefore, the tax has to be by way of authority of law. And now, if the authority of law does not
That
conceptualize any
urban tax is nowhere here.
then under such circumstances, there cannot be an imposition of urban tax.
That was,
Be that as it may, the question of refund does not arise, taking into account that Mafatlal's judgment, the 9 judges' judgment, I'm saying so. But henceforth, you can't unless you put it in the name of some fees and all.
Lordship.
That's another aspect for which you will require quid pro quo. That's the very concept of fees. So, therefore, urban tax is gone. But as regards the other aspect, he was saying that there was no notice or published and all. Now,
Lordship, it was published.
what does he have to say about this 3%? Annual rental value challenged. You are challenging Annexure 9.
yes, yes,
You are challenging Annexure 9.
yes.
Yes.
Okay, what is the ground of challenge?
That is not.
Exorbitant.
Is exorbitant and not in accordance with.
No, what is this exorbitant?
Exorbitant, I have already.
No, forget about
That's
that. No,
what-
what is the ground on which you are challenging? Yes, urban tax is understood, but what about the other?
Nothing is.
Lordship, can we have a look at page 97 of their report? And they impose holding tax such as the and the urban tax. So this tax will go that and thereby our the
No, we can only interfere with the urban tax, remaining cannot happen.
and they impose the tax before the time limit.
Huh?
As per section 79F,
Ah.
as per section 79F, Lordship, kindly have a look at. 3 months notice. The rate of tax is determined in accordance with the provision of this act shall be pursued by the respective municipal services issuing a public notice to include of 3 months from the date of coming to the Assam amendment of such and such. No, I'm sorry. Not sorry.
The urban tax, is it under the municipal act or is it under this Assam Urban Immovable Property Tax Act 1963? This is the provision.
Yeah.
Then this is
But as per the notification of the government itself, the tax has to be calculated as per the section 79 A, B, C, D, E,
no.
as per the notification.
Anything under Assam interest, there shall be cess levied and collected in the municipal board or assessed for every year all the urban immovable property tax on all lands and buildings which are near the quantum of tax shall be 3% of the. So this 3% is as per this act. This will be done by the municipal authority. Ah, Mr. Roy, this is a very sad thing, huh? My person is finding it out and giving it to me.
So that matter has been also placed before the report, my lord, of last occasion. But my friend has said that has been left.
Lordship, I've checked it, I did not check it, Lordship.
No. This is done under the Assam Urban Immovable Property Tax Act 1969, which categorically says levy of urban immovable tax, notwithstanding anything contained in the Assam Municipal Act 1956. This is it. There shall be assessed, levied and collected by the municipal board or the town committee for every year a tax called the Urban Immovable Property Tax on all lands and buildings situated within the area such as municipal board or town. The quantum of tax shall be 3% of the annual value of the land and building. Then, so this is by operation of law.
But as per their notification, my lord, of the government, they are only concerned with the municipal act only. They are saying
No, this will be done by the municipal board itself. That is why they have issued this notification and put it at 3%. This is on the basis of this notification.
that notification, government notification. There are two notifications.
Which one?
My lord. My lord, this act has been abolished, Lordship. I think, Lordship, this act has been abolished, Lordship.
Yes, that.
Which one?
That 1969, Lordship.
Has been abolished?
Yes, sir.
When?
That we have placed before you.
Earlier I have placed, but it has been abolished, Lordship. By act of
The 63 Act has been repealed.
69, Lordship, 69 Act.
Now 69 has been abolished.
Yes, Lordship.
When?
2022, Lordship.
2022. Where is that?
Lordship.
When was this abolished?
Pollution Act 1922.
Assam Repealing Act 2022.
The Gazette notification. Right, Gazette notification, 30 September 22. Serial number 11. Correct.
So, with effect from 7th of October 2022, there is no urban tax.
No. Under this law.
The final assessment was published at 3/5.
Huh?
3/5/2023. Final assessment was.
That is page 36.
Well. Page 36.
What is your reply as regards the urban tax?
Lordship, our reply was that it was collected earlier, so it was been taken to this.
You can't collect it.
Lordship,
You cannot collect it after the repealing.
repealing it was not, but it was continuing to collect. Lordship.
We have to stop it immediately, forthwith. That we have to stop the urban tax.
No.
And what about the other annual rateable value? That it seems that you have.
It
Let's
was,
see your affidavit. What do you say on that? This is your affidavit filed on 24th of February.
yes, sir.
Page 98, that chart shows by them, my lord, how they calculate the thing.
Because it was done as per the government notification, Lordship.
What the contradiction, my lord, may I submit one thing?
No, there was a. Page 1016. Page 10.
Now let's see the Assam Municipal Corporation, because now it has become a corporation, na?
Yes.
No.
No.
Tinsukia is not.
It's a board.
Dibrugarh Corporation.
Dibrugarh is,
Dibrugarh.
it is a board.
I will, after that, I will submit one thing, my lord, for consideration.
So Tinsukia is still municipal board.
Municipal board.
There, it has not become a corporation.
No.
Huh?
Only in operation, the Dibrugarh is now.
Corporation.
No, no, operation. After Guwahati, then only Dibrugarh. You can say second capital of Assam.
And this Assam Municipal Corporation Act did not repeal the, did not touch the Municipal Act, Municipal Board, Municipal Act of 1956.
Yeah.
How is the conversion happening? Like Dibrugarh Municipal Board became a corporation. How did it happen? Any idea? So as of now, you are guided by the Assam Municipal Act.
Yes.
We get one applicant rates.
It is. It was by notification for a special.
And when did the amendment happen in the Assam Municipal Act? Well, you have filed some affidavit.
Not file the reply.
Now, this is one affidavit filed on 24th of February 2025.
This is my,
Okay. Did you file any affidavit?
No,
pursuant that-
no reply.
No,
no reply.
you have no reply. So therefore, they,
Never.
so you have records with you?
Yes.
Before that, may I submit one addition?
Yes.
Lordship, as you have a look at page 98 of the. This is how they calculate the holding. So submitted.
Yes.
Lordship will find, as per this they calculate. Now there is some contradiction. That I kindly from consideration of the economic code point of view. But you will find, here holding tax is 3.5.
Huh?
Yes. They
Holding
calculate-
tax is
yes.
3.5.
Light tax 1%, then urban tax 3%, then sanitary tax 1%.
Hmm.
Total is 8.5%,
Hmm.
but their imposition is only 6.
Hmm.
So they calculated with this 8.5. So entire calculation by respect to submission is not correct, my lord. Lordship, can you consider this? Now, Lordship will also see from the right side how they total cost of land, how they calculate. Now here this ground floor is 1200 square feet, they're taking it. Clean area 1200 square feet into 434.03, that is the land value, into 1.5. So this goes much, this 1.5 nowhere Lordship will find in the tag, in the act. The act is 79B is concerning how the method of calculation of the carpet area. And there is a method has been given in the act. In contravention of this, they goes with this calculation. That also in violation of the municipality act.
Lordship,
Why do you say for the purpose of calculation of the annual rental value of the holding, measurement of the carpet area shall be calculated as under
Yes.
rooms full measurement of internal dimension, covered veranda full measurement, balcony and store 50% measurement of internal, garage 25% and so and so. Okay, then
Bathroom, latrine, portico, staircase shall not form carpet area. Their basing of this calculation of property is not based upon this 79B.
Lordship, this
The
was,
government say, the government notification says directing the municipal board that you have to adhere to your calculation under this 79A to 79B. Now they have not taken into consideration of 79B. How they calculate this cleaned area, the entire value will be go up. 1.5%, my lord, is a considerable. 1.5%, you know.
my lord, it was a proposed and final was page number 125. It was proposed. 125 is the final, Lordship. Page 97, 98 is the proposed. It was earlier proposed.
It's not here, the proposal.
Yes.
let us see this Office of the Year, Principal Manager, report of the property rate tax, total property tax.
This was the
payable
final.
As per old.
125.
New method, holding tax 3%. Okay, but how are you arriving at the annual rental value?
Lordship, it was page 126. Page 126, Lordship, bottom, Lordship.
Huh?
Page 126, but for calculation of property value, because it
In
was
plus 50%.
into land rate, SOR 1314 as per class of land plus building carpet area into PWD SOR 1314. Then calculation of property tax, 7.45% property value less 20 SR, ARV into 14% yearly property tax. This was the final lordship.
Length area plus 50%
Logic.
into
And
land
for-
rate.
Logic.
That is 1.5 million.
Huh?
And it was come from page number 102. 102 is the notification, how to fix this. PWD SOR are there, Lordship.
Of a holding is the reasonable rate at which the holding can be reasonably let out to Iman so and so. Although the computation is not provided in the act, that it is to be cardinal and be objective on the assessment, the municipal boards will follow the formula in the earlier Assam urban area, that is 7.5% of the value of the land and the building. The board may, however, fix ARV lower or higher than the value of 7.5 of the land and the building value on justified ground. May determine the rental value per square feet for categories of and may publish it under 79.
Proposed by. In notification, sir.
Well, you have carried out in this manner as per 101.
Lordship.
Annexure 4.
Lordship. One zero one, 102, Lordship.
Huh? But from where are you getting the urban tax? No urban tax
No,
here.
urban tax was not there, Lordship.
In that notification also only says 79D.
Urban tax is not there.
Huh?
That notification also 102 page number tax only tax. Also will find in column tax only 79D.
May be determined by the concerned MB as per the powers given under 79D. Will be approved by the rate of tax will be approved by the committee as referred under 79AF and the board through a resolution. Now the rate of tax have been approved by the committee.
Lordship, as per this, Lordship, it has been approved, Lordship. As per the record, Lordship, it has seen it. The committee has been formed. If pleases the draft notification for assessment of the urban tax may be approved if plans. This is noting is there, Lordship.
There's no committee meeting, my lord.
Committee is there, Lordship.
Committee is there. but
Yes,
they have
committee
to
meeting.
come.
Meeting is
When the
also there.
committee is there, that has to be.
Now, have the rates been approved by the committee?
That was not here. That was not here, Lordship. In the record, it
That's
is not
the-
here. Only holding of public meeting is there. These are there, Lordship, in the records.
No, but anyways, is it required that the committee has to do it as per the law?
Yes,
Where?
So the approval of the committee is only required, Lordship, as per this act, Lordship. 795 law. For in- Would work it out to go.
579C, my lord. he has- Prior approval. Rental value per square feet, my lord. That has to be approved by the committee.
Is it, have you made any statement that in your petition and the affidavit that you have complied with 79C?
Subject to correction, my lord, I have not find any.
But we have only because.
Let me see the records.
Lordship.
What is this Assam Municipal Amendment Act 2022?
With 22. Say 22. Corporation is invented. This is. Not true.
Twenty-two to property taxes asset. Property tax on land in building. 22 to, deputation by 22.
You have the communication dated 5/8/2022. It's there in the affidavit. Page 113. So here there is a concurrence with the committee.
Yes.
Why you are saying no?
No, Lordship, I'm saying, Lordship, it was a concurrence with the committee. That's why I'm saying.
Under the provisions of so and with approval
Yes.
from the committee
The-
constituted under the said the following roads have been reclassified as so and so, so and so, so and so.
Thereafter, publication was done.
Publication of the classification and declaration of holding so and so. 8/8, it has been done. Mr. Dotto, did you make any objection to the, file any objection or claims pursuant to the office memorandum dated 6/2/2023? That is publication of the draft assessment list of holdings and notifications.
That was the calculation. That was not answered by that.
I'm asking you, you did not raise any objection?
Record.
The rate has been fixed as the manner in which it is being done, it is done by the government.
Yes.
As per a notification dated 10th of March 2023.
Yes.
The rate of construction of the houses shall be as per the CPWD Delhi rates. The rate of construction of the Assam type shall be considered at rupees 1500 per square feet or 50% of the PWD area.
That 10/3/2023 notification, they have revisited now. As per their statement.
Or whichever is less. If ULB fails to analyze the rate of construction of a thatched house should be so and so, the property tax for so and so within the year may be charged a year. Now you have revisited this. The government has to revisit, not
Government has to-
Tinsukia Municipal Board.
Government,
What has the government done?
that they have hold a meeting, my lord, because in that notification, there is a proposal of rebate of 25% of the last enhancement would be 25% from the last
That-
tax. When we raised the issue, my lord, then they had a discussion with municipal board with the government. And as per their submission in this reflected in the audit sheet of the board also.
There will be.
For residential building, maximum 25% will be there. For commercial, there is no rebate, so and so. That is again publication of draft reassessment list with new rates, Tinsukia Municipal. Assam type house, 936 per square feet. RCC floor, 1634, others, 1500. Publication of this has been done. Shall be offered a period of 1 month to lodge their claims and objections as per so and so. Notification published.
Now, in 10/3/2023 notification, my lord,
Ah,
that as per clause 5,
ah.
rebate can be given to the public so that the effective increase to the final property tax shall not be more than 25% of the last property tax collected depending upon the local condition and requirements. During the pendency of this writ petition, my lord, we brought this notification to the record. Then they asked for a time from this honorable court to have a discussion with the government, and ultimately they have submitted that they revisited this notification.
And it was in the first records, first page, Lordship, the communications were there, Lordship, that it has been revisited and it has to be by way of a corrigendum, it will be come up. Till that, it has not yet come up.
The honor to enclose here with a copy of the letter.
This was in the
received
record,
regarding submission of clarification to the government.
That 25% was last.
And for the challenge the recent reassessment, they have also. Alleged the challenge the reassessment. The rebate can be given. To final.
This notification, lordship will find on page 59. Is it? 40.
Not yet done.
No, this final assessment 3/5/2023 says annual rental value is considered 7.5% of the property value For RCC buildings, public institution, Assam type buildings and others, 25% concession on the total tax of the buildings shall be provided. For religious, 100% concession. For commercial, no tax. For both so and so is carbon tax in here. For RCC building, Delhi so and so. For land valuation, zonal so and so has to be considered. Then where is the question of what is a rebate can also be given to the public so that the effective increase in the final property tax? Where is this guideline? He is referring to which one?
You will find page
This is
49.
of 10.3.
Page 49.
10.3 is what? 10.3.
10.
This is by the government.
Government, and that has been acted upon by them.
Thereafter, Lordship, we have taken a clarification on that. It has been, I have already submitted
They are
there.
acted upon that notification. So entire thing will come, my lord. When the-
No. But the thing is, can the government say all these things when the power is upon them? I think this is we need not challenge touch anything on the annual rateable value. It's okay, but the urban tax you cannot levy. You may take it up in the name of the latrine tax or water tax, whichever you are.
This was the minor, that the corrigendum has last part, Lordship.
Notification shall be dealt with by But you have, on the other hand, you see, in continuation of the letter dated so and so regarding the drive and for the property and the urban, the government of Hausa is pleased to issue the following guidelines. These are guidelines only.
Lordship.
These cannot be the basis, but you have given 25% reduction in respect to those in your final notification.
Final notification given, we have
Also,
taken.
on the total tax of the building shall be provided.
Lordship.
You have given that.
Lordship.
But what does it mean by this 10/3/2023 mean? From the last whatever it is, if it is more than 25%, this is something is wrong with them.
Yes,
Rebate
that-
can
that-
be given to the public so that the effective increase to the final property shall not be more than 25% of the last property.
Last property.
Ah.
On that, we have taken a clarification.
Not necessary. I think we partly allow his petition. Urban tax, you cannot unless you do it as per law, but remaining, I don't think there is need for any touch.
Lordship.
And there is no question of any recovery
Lordship.
or refund, but for henceforth you are not going to lodge it.
Then they are required to, my lord, revisit the assessment of the tax also.
You have not submitted your claims.
No.
First of all, your repetition should be, you see, your repetition, you had been given the window for filing objections. You have not.
My lord, what happened, what they did also not comply. They did not, this final assessment, neither this preliminary, not final. They have not published it yet.
No, they have published it.
Not published, but it's not prior 3 months notice. That there is some technical difficulties on their part also. I am not on that. Lordship is on the final conclusion now. They are very hurried, my lord.
The rate of tax determined in accordance with the provisions of AR shall be published in the respective so and so by issuing public notice within a period of 3 months from the date of coming into force of the so and so. Within a period of 3 months from the date of coming into force of the 2012 Act.
What they did, my lord, I'm just coming to that, my lord. The draft notification is dated 20 February 2023. And
Final notification was.
1/3/2020, the board meeting was held on 29/4, public meeting, and 3/5/23, the final assessment.
Let's see 79F. You are referring to 79F. Let's see, read it.
The rate of taxes determined such and such shall be published in respect of municipal board by issuing a public notice within a period of 3 months from the date of coming into force of municipal amendment 2012. This will not come.
So therefore, where is,
Period of 5 years. At the expiration of every 5 years, new determination of rate tax shall take place and shall be published in the manner as stipulated in this section. That is the 3 months. So therefore, I will not do that, my lord, but because of the tax, this they.
no, you have to understand this. At the expiration of every 3 years, 5 years,
5 years.
new determination of rate of tax shall be take place and shall be published in the same manner as published in this section. Now, here the last determination was done in the year 1975.
Yes.
You have to see 79F came only in the year 2012.
Correction. New determination of rate tax. Now it's a new
Understood.
determination.
Understood. But this is for the first time after 2012.
Correction for consideration. Now the 3% my tax calculated with a radar of this 6%. Now it will come in by 3%. So it has to be newly to be calculated by them. That's they will take the.
No. Oh, whether they calculate, they have as of now not.
It is there.
You got a stay order, na?
No.
Yes.
So
No
you, have
corrosive
you,
action.
No court to be.
No corrosive action should be taken.
so you have not paid.
Not paid.
So if you have not paid, you don't need to pay the 3% of the urban tax. But as regards, because this will have a far-reaching consequences upon all others. So therefore, the question is, there's no refund business because nobody has. But they cannot impose this 3% urban tax, taking into account that urban acts or neither section 79 provides taking into account here. They may to do it in whatever name the other names. That is the best.
That index also they cannot impose, my lord. That is subject to section 71. So section 71 says that you have to provide the survey. Nowadays, there's the earlier days, my lord, that's no kacha latrine, etc. Then that latrine tax. And water tax, since you have no supplied the water to the citizen, you cannot impose what. That's the substance
71.
of the section.
Chalo. I think I'll make it CAB. I'll keep the records. Because it has been done. Otherwise, the other formalities have been fulfilled. And let us not go and trouble these ULB people out there. They have no business out there. They are not bothered. They first take away the right of you to collect urban tax, and now they don't fulfill it by giving you anything. Isn't it? Anyways, who has taken that 10,000? It is given there, huh? Good. One good thing.
You'll get the benefit, my lord, of 10,000. We'll get the benefit.
This will be given by the DLSA.
DLSA.
And another 10,000 upon you for unnecessary spoiling the time.
My lord.
10% you are getting. So
You
anyways.
can always say yes to my lord.
Anyways, I'll have it hearing completed, judgment reserved. Mr. S.S. Roy, the Learned Counsel, appearing on behalf of the Tinsukia Development Board,
Municipal.
have produced, Tinsukia Municipal Board have produced the records. Stop. The records are presently the courtmaster is directed to take these records along with the records of the present proceedings. Stop. CAB.
Grateful.
Zero. The contract was given to me. And I was appointed by letter dated 26 February 2020. Immediately at that time, my lord, the COVID period started. So I could not perform the contract because the Indian they were spending for giving track and all. I failed. It is an admitted position. Thereafter, they appointed one ad hoc contractor. Since I failed, ad hoc work, and that was recent boss. but his rate was double my rate, double. So FCI did not engage in much matter for a limited, only 117 MT. Top. Then another ad hoc was given. Now that risk and cost, though that other contract which was given, it was not mentioned risk and cost. Even though, my lord, FCI deducted 2.3 lakhs from me, that I paid, that is not an issue also. Thereafter, my lord, another ad hoc contract was given, and he continued till my tenure. But his rate was equivalent to my fee. So therefore, risk and cost did not impact me. Now, by the impugned order, which has come from the CAG opinion, my lord, what FCI has done, my lord, has deducted 38 lakhs from other contracts, saying that, my lord, in the same zero, my lord, FSD, my lord, another person was from Bandardua, another contractor who was appointed earlier than me, my lord, he was delivering. Now, CAG has opined that if I have failed, so this work was possibly this given to him. So he has done my work, therefore my rates have been differentiated with his rate, and my lord, some figure has been worked out, my lord, that 38 lakhs I have to pay, and that is under calculation. My contention is that, my lord, if a contractor fails, my lord, they can do one thing, liquidated damage, 10 lakhs that I have paid, my lord, that is not an issue. But that risk and cost, that rate became equal, so that did not impact me, my lord. So directly they could not do anything, so indirectly they have taken a resort that another contractor who was engaged earlier than me, not for my failure, my lord. He was from another same destination, said that no, since you have failed, he has transported on your behalf, so that rate difference that you have to pay, my lord. My submission that, my lord, under terms of contract, my lord, this mode is not permissible, my lord. Lastly, may I return to, my lord, that my NIT, my lord, that you will find at page 61, my lord.
Yes. Then,
61 is the, my lord, then appointment order was issued at page 67.
which are the terms for risk and cost?
My lord, that is MPF that I have included in my reply, my lord. In my reply, as a division reply, I have included MPF, my lord.
Yes. Where is it?
That will be page 338. Clause 11, down below.
Yes, where?
My lord, last clause, my lord, clause 11, sir. In the event the contractors having been just insolvent or going into liquidation or winding up their business or making arrangements with their creditors or failing to observe any of the provisions of this contract or any of the terms and conditions governing the contract, the general manager shall be at liberty to terminate the contract forthwith without prejudice to any other right remedy under the contract and law, and to get the work done for the unexpired period of the contract at the risk and cost of the contractor, and to claim from the contractor any resultant loss sustained or cost incurred. The general manager should also have without prejudice to the other right and remedies, the right in the event of breach of contract of any of the terms and conditions of the contract to terminate the contract forthwith and to get the work done the unexpired period of the contract with the risk and cost of the contractor and or forfeit the security deposit or any part thereof, the sum due to damages and losses.
Hey, take it the option. Sticker. Yes. Take it.
My lord, then clause 10B, my lord, that is liquidated damage. 10B, my lord, liquidated damage is not an issue, my lord. Liquidated damage, they have imposed 10 lakhs. I have paid, my lord.
How do you say 10 lakhs?
No, 10 lakhs has been calculated at the rate of 300. They have mentioned, my lord, Please. Out of 45 lakh.
10A,
My lord.
10A and 11, nah? Now what happens next?
So this, now thereafter, my lord, that my lord, the work was given to me. I was appointed page 67, my lord. I joined page 69. 67, my lord. I was appointed, my lord, for 2 years. Now I have to deposit all this, my lord. Security deposit and bank guarantee.
This is your letter. Where is the appointment letter?
Now, this, my lord, page 67. I was appointed. When I joined, that is 59, my lord.
So quoted rate is 2288 for 2 years.
2 years.
So there is no quantity mentioned. Isn't it?
My lord. I-
So the thing is, you are to supply at rupees 2288 per metric ton for entire distance from
Fine.
0 to,
not looking to zero.
from North Lakhimpur to FSD 0 for a period of 2 years.
Value of the contract has been mentioned in the thing, my lord.
Where?
NIT 62, page 62, my lord.
No. You are appointed for 2 years
2 years.
at rupees 2288.
Yes, ma'am. That was made.
So there is no metric tons given,
No, ma'am.
isn't it?
One point to another point.
Now next.
Next, I joined, my lord, page 67.
Now where is the termination?
Now, that ad hoc Russian candidate, my lord.
Now where is the termination?
My termination is not there, my lord.
What?
Termination is not.
No termination? How?
It's a-
No, Lordship is, will come to page 339. 339,
Yes. Yes.
clause 11C,
Page 60?
page 339, the region under
339.
five. 339, the MTF clause. Lordship got it.
Will be
no?
responsible to supply adequate and sufficient number laborers and trucks and so and so and so. If the contractor fails to supply the requisite numbers of laborers and trucks and shall be at his discretion without terminating and be at liberty to engage other laborers at the risk and cost of the contractor, who shall be liable to make good the corporation all additional charges, expenses, costs, and so that he may incur to suffer. So this is without termination, no?
Without terminating the contract, because he has
So
failed.
it is not under 11A or
No,
B, but it is under 11C.
Lordship.
Okay.
My lord. 7.
Then
Then page 144, Lakshmi Kanisi, my lord.
140.
44, my lord. My lord, this is the ad hoc which was issued, my lord. And
This
Lordship
is a
find-
notice inviting ad hoc.
ad hoc, my lord. So here, my lord, here your lordship will not find any expense cost mentioned. Because that time was, my lord, there was.
What is the period from?
It's 6 months and 9 months. 6
No,
months.
for 2 years with effect from?
My period was, my period was from 26 to 2020 to 25 to 2020.
23?
26 February 2020.
23 February 2020, 26.
To 25 to 2020.
5 to 2022.
Madam.
Okay. Okay, now this is given on 22/7/2020.
6 months and extendable by another 3 months. .
Then,
Then it was, Malad, here in the NIT, Malad, though, risks and cost is not mentioned, Malad. Maybe it's due to the prevailing situation, Malad. Then 154, Malad, page 154.
now, where have you been informed about the risk and cost?
This one, page 154, Malad.
Hmm?
154, while appointing the contractor, it is mentioned that it is.
No, where prior to issuance of this notice inviting ad hoc tender, where you have been informed about the risk and that they are initiating action under 11C.
That even in the tender also, risk and cost is not mentioned, Malad.
Okay, then
154, Malad. While appointing that defense Shaikia Malad, that ad hoc tenderer, they have mentioned the different risks and costs of the existing contractor.
at the existing contractor. Then,
Now regarding that, they have imposed a cost upon me of 2.3 lakh, my lord, as I submitted, my lord. This is not an issue in this present case. I'm just narrating the facts, my lord. Regarding that, I am not seeking any relief, my lord.
okay.
Then, my lord, another.
So
ad hoc
the
order-
rate quoted is 3,990
Yes.
and your rate is 2,288.
My lord, 2228 was almost double,
And this has now become 3,900.
3,000.
This is given for how, what is the period?
My lord, they, FCI only operated, understanding that risks, rate, my lord, only 117 MP, my lord. They did not operate risks.
How do you know?
Instead, my lord, I come to that, my lord, that has been mentioned subsequently, my lord.
Hmm.
So, my lord, what it did, my lord, they issued another ad hoc tender.
No, wait. Okay. Then, where is the next tender?
231, my lord.
Okay. This is on 24
24,
4
4,
2021.
Here it is mentioned clearly that at the risks and cost of the defaulting contractor, Anup Trade and Transport.
Where?
That table is there, my lord. Middle one, my lord. Road transport contract. Not lock me to 0. I have to enter the risks and cost of the defaulting contractor. Anup
Which clause you are referring to?
My lord.
Which clause you are referring to?
Clause.
In the middle, my
In
lord.
the middle, my lord,
In the
231.
231 or 228? Isn't it the same or different?
No, 220. 220 is different.
What is 228?
220 is the another regular contract which has been given after completion of my term. That is also nothing to do with this case.
This is also 23/4 2021
Yes, my lord.
and the other is from the
No, this is also one of the, because 229 lordship will see. Next page.
this is also 0.
Lordship. Anup Trade, existing contractor, Anup Trade, risk and cost.
They mentioned it, risks and cost and everything, but this contract was given after my tenure was over.
How do you know? Because this is your tenure is to be over only on 25/2/2022.
Yes, sir.
But this notice inviting tender came on 23/4/2021.
Yes, sir. Yes, sir. For regular contract.
No, this is also risk and cost.
Regular. 20 years for regular.
How do you say so?
No, it's mentioned, my lord. 2 years time,
Where?
228, my lord.
Where is that?
My lord, second line, my lord. Online tenders invited for 2 bid system, so and so. As per condition prescribed, for appointment of regular basis for 2 years.
So this is for 2 years.
For 2 years.
No, this is
This
for
nothing to do with
handling. This is handling contract. First one, my lord.
uh,
There is a handling contract. FSB.
where?
The first one, second one is,
259.
yes.
But it is mentioned, my lord, this tender was for regular tender, my lord. At the top it is mentioned.
No, my
for a
lord,
period of 2 years.
2 years.
229 is my word, that was for 2 year regular contract.
No, my lord, it's 229, it's clarified, my lord.
But,
220,
but 229 also says
Oh, no, yes, madam.
there is part B.
yes, for
Part B says-
unexpired period up to 25 to 2020. For the unexpired, his unexpired period, up to in the table B, last line, for the unexpired period to 20, up to 22, this is his period.
My instruction is that they took time to finalize this.
So this is the second contract, the
was
second.
regular.
And what is the other one?
The ad hoc is.
That is also another one.
231,
Ah. So there are two notice inviting tenders.
my lord.
One is 229 and 231.
My lord, one is ad hoc and one is regular.
No,
Yes, madam.
no. Kindly come to B. Road transport contract, so and so, 229 says, road transport contract X siding, so and so, via risk and cost of the defaulting tenderer, so and so, for unexpired period up to 25 to 2022.
Mentioned, madam,
Yes.
for a regular period, regular contract for 2 years. But my instruction, my pleading is that this, they can clarify, my lord, this contract was given after my tenure, madam.
Okay.
During my tenure only, the ad hoc one continued, madam.
Okay, let us see. And then we have another one on 24/4/2021, the next day.
Yes, madam.
Again, another, this is for road transport.
It is, no. Second one, that is, second two to.
Okay, then
Then his rate was, my lord, that ad hoc rate, that was equivalent to me, my lord. His rate was 2,333.36.
okay, now show me the impugn order. Let us see.
Madam.
Enough. Where is the impugn order?
280, madam.
280. Extension of benefit to the contractor appointed as RTC on recovery of Iman is pending for settlement. The total value in question has been awarded, worked out to rupees 45 rupees, so and so. Received from okay. Then
So from 3 other contracts, my lord, this amount has been deducted.
extension of
45
undue
29,000.
benefit as per so and so of the RTC.
Now, CAG,
Assam region and
Opinion is
stipulates that the condemnable has the Okay, now I get it. Your case seems to be like this. You were initially appointed from FSD Lakhimpur to FSD 0 for a period from 26 to 2022, 25 to 2022. The total quantity which was given to you or indents given to you for supply was to the tune of some 33,000 metric tons.
3,950.
There's a shortfall of 32,000 metric tons. What they did,
But my lord,
wait. What they did, they not only got the supply done from Lakhimpur to 0, but your grievance is they got the supply done from Harmuti to 0 and another place, Bandadua to 0, which is not a part of your contract. So as such, the risk and cost imposed of 20 lakhs could not have been done upon you. And that is the 20 lakhs by which the audit objection has come in. Where is the audit?
That's why my audit objection was taken up to the period of, the entire period was not available. So they have given the methodology, say that you worked out, and they have worked out, my lord.
Where is the audit paper again?
My lord, page 287, it will be clear, my lord. I asked for clarification, how did you work out this?
This is. So you supplied only 1371
Yes, sir.
out of 33,950.
My lord.
So your case is, how on earth you are applying the risk and cost by supplying from Harmuti or Bandadua to 0,
Yes.
which is not a part of your contract.
That, my question, can you see another thing, 292, Lordship, can you see, my lord? I have enclosed that, that appointment order, my lord, TTK Enterprise, my lord, that they are taking resort to. This was pursuant to an NIT of 35/2019, prior to me, my lord. And
No. So
This is not
therefore, you say that it is not at your risk and cost.
Yes, that.
Now the question is whether the risk and cost has to be only for the area which where the contract was given to you, or can be done by wherever they try to fill up the coffers out there to the tune of 33,000 metric tons. That's the question.
There has been mentioned that if I fail, additional contractor will be to do the work undone by me, and then I am liable. It is not that anybody is sending for any place and the risk will be different and then it will be calculated, no, you have to pay this. Because FCI failed to recover because the risk and cost and my rate became same. Had it been higher, I would have definitely been liable, madam. So they got it done through a risk and cost contractor, but from this contract they could not recover. Yet, out of the blue, said that no, you take that.
Mr. Roy?
Well, Lord, first, Lordship will look into 11C again. It says that if the contractor fails to supply the requisite number of labor or trucks, the general manager shall, at his discretion, without terminating the contract, be at liberty to engage other laborer trucks at the risk and cost. It doesn't say about the same route, or you can engage some other trucks, some contractor, some.
Then tomorrow you can very well engage from Guwahati. How does it become?
No.
But Mr. Roy,
No, my lord, will kindly see one thing. The North Lakhimpur to Teju. Zero, I'm sorry, 0. So it goes via Naharlagun.
No. Not Lakhimpur to 0 does not go through Naharlagun. It goes to Kiping.
But Naharlagun is a center.
Naharlagun is pretty far off. It's another 30 kilometers from there. From Kiping's point.
Right, my lord.
And if you take that particular
because we cannot, because we have to feed the destination center. We have to feed this way or that way. We have to feed. We cannot keep them, the go down dry. We'll have to provide food grains. So if he fails, we can adopt other measure. And he himself said, my lord, will kindly come to page 267. 267 for a while.
What does he say?
267. He says, faced with the impediments, unrealistic so and so, preferred application so and so grievance redressal without prejudice, suggested the FCI. He himself suggested that the FCI may approach parallel contract from ex railway station Harmoti. He himself says. Well, that is what we have done.
Are you saying that because of him, you have approached?
We have
Then why have you issued the notice inviting tenders?
noticing in a tender, but because of a failure for a particular, this is for a particular period.
No, you
First
have-
one
you
is
have-
for
no,
only
you
for
have
up to
issued
May.
Two notice inviting tenders.
But one is
One
only
is
for
on
6 months.
23/4 and the
Because, my lord, when we issued notice in the tender, it is in addition to him. He was also simultaneously directed to provide trucks. It is not that in his place. He was also directed. He provided, but less. He provided. But if he was asked to supply 100 trucks, he supplied 220 trucks. That is why the deficiency. My lord. It is not that in his place we have engaged in.
But your audit objection is not based on 11C. It is based on 11A and 11B.
No, my lord.
Yes, have you ever read it?
11, it does, maybe, my lord.
No,
but
this
then-
is a very important thing. That without
My lord,
termination, how are you
audit-
going to do
oh,
that?
No, no, it's true, my lord. Audit has raised an objection.
Huh.
Decision has to be taken by us.
No, but you have taken the decision based on the audit objection.
No, audit, since objected, we have to regularize the audit objection, my lord. That is a different matter.
Understood. Thereby, you are.
Audit is not
taking
the
money
authority,
from-
my lord. Audit is not the authority. Audit is only, my lord, to check the accounts and point out the
Okay, now show me where is your demand
demand, my lord.
of 38 lakhs?
My lord, it is provided in the contract itself. And he has himself, he is agreed. My lord,
No,
he
no, no,
is,
no, no, no. Risk and cost you want to do it. I'm understood. That how much is the amount? Have you informed him?
yes.
Where?
My lord, kindly see, he himself wanted to give me the amounts. We have given him.
Where?
My lord, kindly see that. No, sir. 287. $287. Furnishing details.
Yes. With regard to the above cited, it is to inform that CAG paragraph 5 has been examined while processing NDC pertaining to the contracts awarded to it. Has been observed that in the said para quantity transported through L2 was considered from the months of. However, from the para, it can be seen that CAG has stated. And hence, it is evident that during the period so and so for the same route and so, there might have been significant. Accordingly, the quantity of so and so for the period from has to be considered to a certain day. In view of that, the office has requested RO to furnish the quantity of stock from so and so in connection with Iman and has stated that the quantity of so and so food grains was transported from Iman to Iman for the period from Iman to September 2000 Iman. And worked out the stocks were transported from Harmuti to so and so by L2, which is at the rate of 252 per metric ton. Accordingly, the total expenditure considering rupees 252 metric ton for Iman was calculated, which comes to rupees 38 lakhs per Iman. In addition to above, the CAG has also mentioned that there is an existence of a short recovery of Iman. Subsequently, upon financial concurrence and approval of the continuing Iman has taken. So your entire basis of
This
the-
is not challenged. my
No,
lord.
no, your entire decision is based on the CAG.
But this is not challenged. Neither CAG report nor this order. This is not put to challenge.
No, it is not required for that to challenge. Whatever he is asking, that is consequential. There's not a question out there. But the fact remains that you have asked that, okay, this is 252. What you have done is you are only asking him at that point of time that whatever additional amount apart from the 10 lakhs which you have already recovered, another 7 lakhs you have taken on the basis of that particular person who have supplied at 3900, any additional amount which is there for which
Because
you
of his
already
failure.
taken the 7 lakhs from him. Now, in respect to the other from Harmuti, there was an additional amount of 252 from what it is.
And then this we had to, because this amount of food grains were not supplied by him. And therefore,
Understood, but how can you apply from Harmuti?
Harmuti, but not he himself said, as I pointed out, he himself said, from Harmuti you can engage. He himself said twice, not once, twice, thrice. He made repeated representative from Harmuti, you do it. So
Well,
he
that-
cannot now raise the plea without the Harmuti, it was improper. He himself said.
No, that is his case.
But
You-
he has himself said.
Let us see where.
My lord, kindly see, not just once.
Two.
Petitioner, my lord, before the GRC, and this order is, GRC has passed an order rejecting, this is not challenged.
No, that we'll take care. Don't worry. Where is that he's saying from Harmuti?
Oh,
267.
two.
267. He said.
267. Oh, yes. Yes, 267.
Which paragraph?
He said he's ready to pay. Paragraph
Where?
69.
Huh?
Para 69.
Which
Not,
with the such impediment unrealistic to be preferred an application before the grievance wherein we without prejudice suggests that the FCI may approach the parallel contract X railroad demand for this tender to fulfill the remaining tenure of the tender, and we were ready to pay the difference of the amount to the parallel contractor only because we have tried every possible means to complete the tender peacefully, but the concern never said anyone. Okay, because of this.
because of this, my lord, it is his contention, my lord. He cannot now raise this plea, my lord.
Mr. Chakraborty, this is very damaging. Matter over. Because I would not have otherwise, because you said this very thing before the grievance redressal form. And you say that you have not taken into consideration that. This is your explanation. But the concerned authorities were never satisfied and making unrealistic demands. You said that that application wherein 83 2012 before the remand, wherein without prejudice suggested FCI may approach the parallel contractor to fulfill the remaining year. This is your grievance.
But Lordship Dynasty, in that, that was the situation, but FCI appointed a different contractor for that, ad hoc one.
Whatever may be, but they have taken it from railroad. And this is the total amount. The additional amount which is there is the amount that is 252.
252 per MT. That
Per
is
MT.
rate-
Earlier it was, your rate was 2288. So they have given it to Harmuti must be at 2288 plus 252. It was 10, 1, 13, 14, 1, 5, 3. 3,540. 2,540. 2,540 they have given it to this Harmuti one. That is how they did it.
No, my currency, my lord, the calculation they are given, my lord, that is also my contention, my lord. That, clarification they are getting 287, my lord.
No, no, calculation appears to be okay.
No, my lord, no, one figure. What the basic figure, my lord, that 287, my lord.
Yes.
287, they said that at the rate of 250 PMT, I am liable to pay for 15447.294 metric ton. That they have worked out, my lord. My lord, why from they have worked out, my lord, I am showing, my lord. Lord, you can see that the contract which was given to that Harmoti to so and so, my lord, that can see, my lord, 292, my lord, 292, 290. I mean, know that much.
Yes.
He, my lord, can you see his date was 2550. My lord, calculating that, my lord. Can you see? He himself was liable to transport 25,000 MT under his contract.
Hmm.
Now, how much he has, over and above that, how much he has done? That is not on record, my lord. That 1554, where from they have calculated, my lord. This is my second leave, my lord, second leave of argument, my lord. That what, 15.
You should be happy with that. Only 252 is being charged.
What?
You should be happy.
My lord, that, when I say that, you can. engage-
Because he is giving you at a rate of 2019 in 2021.
Worked out my rate and that Harmoti rate.
Understood? 2540 is a rate from ex Harmoti to 0. And this your rate was 2288 from North Lakhimpur to 0. So from Harmoti with this additional amount which is being taken per metric ton is 252. But that is a rate in the year 2019. Remember that. Whereas in 2021, this is being done. 2020, it is being done. So therefore, you are being given at the rate of 2019. You should be happy with that. I think they should charge more.
Method they have followed, that is exactly the method of Briggs and Costman. Briggs and Costman, a contractor who has been engaged in my place as per the clause method to do the undone work, my lord. If the rate difference, that is the method they have adopted, my lord. My only contention is that under the terms of the contract, my lord, Briggs and Cost, what they put me in danger, that I have escaped because his rate and my rate is equivalent. Now FCI could not do anything from that, so they have resorted to another method, my lord.
But are you therefore saying that this particular document, which you are saying out here, that there was no supply of 15547.294? Is it your case?
But this is my second leave, my lord.
No, second leave means you have to challenge this document.
Yes. This document has been issued to me when I issued a letter to him that he have deducted this amount on the basis of tax. Give clarification. This is only clarification. When I asked for, my lord, they have given the account, how they have calculated, my lord. But the impure order.
Now, is it your case that 15447.294 is not the quantity which was actually supplied? Fantastic. Then go to the civil court. No. I cannot decide on that.
No, my lord, that's why I said this is my second argument.
That is your very
My lord.
bad argument.
My argument is that how they have worked out this is not record, my lord.
Hello. Dismissed. We'll get an order.
Last month, up to date progress report, that is not 31/12/2025 up to 25, that has been filed. Some progress has been made, my lord, some persons there, and some whole cases, my lord, that accused are appearing, my lord. And so far is, my lord, CL number 27 is concerned, that is disposed of by this honorable court also.
Which page?
Page, my lord, that is a report, a recent report, my lord, up to 31/12/2025.
Leg X.
My lord,
Flag X1.
flag. That's the man. Report dated 8/1/2025, 26. Office note 8/1/26. Flag B and C, my lord. ABC, my lord. Flag ABC. Flag A. Flag A. No, flag A, my lord. Flag A, look, A, B, C, B is in respect of probably major.
The
Earlier, this is 23rd November.
No, that is, my lord, probably it was submitted on 8/1/2026. Office note dated 8/1/26.
এখন পাইছো। Okay. Updated status. Yes.
Yeah, so far is my lord 27 is concerned, CL number, as in respect of Morigao. I acquired, my lord, I came to know that that is already been disposed of by this honorable court. That is, my lord, dismissed. Dismissed on 24/9/25. State, the remark is that, my lord, stayed by the honorable Guwahati High Court, case number, criminal petition number 36 of 2023. And probably it was dismissed by your lordship, my lord.
Serial number.
Serial number 27. By your lordship, my lord, that is Ramakanta Deoli. I have inquired, my lord, I came to know from my internet. So other, my lord, your lordship kindly see that serial number 11 is a old case, my lord. Dibrugarh.
Mr. Director Prosecution, what do you say about the serial number 11?
11, your lordships, it's a very old case, my lord, 2003 case. Here, my lord, the witnesses are so many, my lord, so many witnesses are there, my lord.
But none of the witnesses are present on 3D. 17/11, 5/12, 22/12.
Yes, sir. And in PW, sir, my lord, absence.
CRPC, no.
Same is web also. 13.
এইকেইটা নতুন হয়। These two are new, but this 11, something has to be done.
Lordship.
these vigilance cases 22, 23, 23 and 24.
Lakhimpur.
And 22 also, why the court is not taking action? It's a complaint case.
Someone issued to the complaint.
After the last order which has been passed by us, taking into account 256 and all.
So far is 27 and 28 and 29 is
22.
confirmed.
22.
Yes, 22, my lord. Yes, complainant did not appear, last date fixed.
Why summons are to be reissued?
My lord.
Is it ever heard of
Yes,
this type of here? Which is
reissue of someone to the complainant. That was the first. For me to figure out what I mean, sir. No, পারে তো, আজিকালি নতুনটো নাজানো কি হয়। সব জানি, তো খালি, তো ফরমান।
They will use by the section 214 and 256 maybe.
This can be very well closed. If there, you don't issue summons to the complainant again to appear.
In our conference, every month we have conference with the SPs and the PPs. We already direct them to, they have used the sections 249 and 256, as well as the what Supreme Court says in Usman Ali cases. Already we have distributed the judgment also to all the PPs and all SPs.
It seems this judge in Kokrajhar is not aware of this order which has been passed by us. Order of 23/10/2025. लिखी हुआ है। Order to दिया नहीं मिलता। This clearly notice है। तो कामरूप की तरफ से but anyway, this order is there.
They should have circulated all this order in all pending cases.
All pending cases. Order to call everybody. এইটো লিখি দিব লাগিব
এইটো সার্কুলেট কৰিব সব কৰি নেক্সট ডেটত এইটো যেটো 11 টো কলে যে এইটো 23 হয়নে 2003 এইটো কিন্তু মোৰ এখন হেৰিত লিখা আছে 2023 এইটো 2023 বুলি আছে এইটো অলপ ডাউট হৈছে এইটো
Sometimes we have to take proactive steps. Because our order is clear on earlier occasion, but despite that PWs are not appearing, these are cases of 2011, 12. Otherwise, those complaint cases, they have entered appearance. And after our intervention slowly progressing, except this Kokrajhar, why someone is issued, we are not aware, maybe that order was not circulated.
Who is paying for state of Arunachal Pradesh?
But my lord, serial number 11, there is little bit confusion.
Confusion, maybe 2023.
23 probably.
003. The earlier report was mentioned as 95 or 2023.
Here again, it has been 2003. Serial number 11, my lord, Dibrugarh.
Is it 2003 or 23?
My lord, yes, in one report, it has been written, my lord, 23, and another report is 2003. But both were presented by the registrar.
But here it is 24 written, CR number, Kokrajhar 40 of 2024.
Cell number 11, you know.
Okay. sir.
Dibrugarh.
24. Someone wrote us this.
Yes, ma'am.
Earlier report.
11 to 23, 2003.
But still,
Mileage. Yes.
23, then also 2 years.
Mileage, yes.
Don't take a standard that it should be for, it should be pending for 5 years. Then only.
Mr. Odhikari, you were there for state
Yes,
ownership
yes, sir.
audits? Kindly come at serial number 4,
Yes,
PGM Court Changlang.
yes, ma'am.
Why this service is not being affected? And do you have a director of prosecutions in the state of?
Yes,
Arunachal?
Malad, we have appointed him on 5th, 9th of May 2025.
So
I have the document,
you'll ask him to be present virtually.
Malad. Yes.
Ask him to be present virtually next time.
My lord.
Because he is the person who has to enforce all this.
Well-
Do you know the name?
Just let me check, Malad. Yes, Malad, Nani, Sri Nani Grayu, Grayu. Nani Grayu.
He was a judicial officer.
Malad, he's a Secretary Justice come legal remember, sir. Government of Arunachal Pradesh. Yes, ex-officer director of prosecution. He was appointed as ex-officer director of prosecution.
How is
I have that
possible?
notification.
LRN director, that is why I'm saying I know.
That's not, Malad, he was
Officer
appointed as
is
ex-officer director.
officer.
Ex-officer director.
How can that be?
This is what notification I have, Malad.
It's enough.
LR cannot be the director of prosecution.
Yes. Well, this notification is of 9th of May 2025.
Cannot be.
And also may have a look at it.
See, you have said it's correct.
Why this is almost 8 months back, 7, 8 months.
Malad.
Then 7, 8 months, why there is no director of prosecution?
That instructions Malad, I don't have as of now, Malad. If somebody has been appointed, because Malad,
On this,
Mr. Chandran was dealing with this matter, Malad. Mr. Chandran, Malad, he was dealing with this matter, Malad. So he's only, since he is not appearing today, due to some difficulty, that's why I came in. So Malad, that instructions I don't have, whether any, Malad, full-time director has been appointed or not. So I can get the instructions, Malad.
or whatever may be, but
Yes.
next date when we fix,
Malad,
whoever it is,
My
the
lord.
ex-officio, whoever it
My
is
lord.
shall be
My
there
lord.
on
My
the
lord.
next date.
Malad,
Huh.
My lord.
And you also answer as to whether this is permissible.
Malad. Malad.
I can BNS. Hey, BNS, BNNS.
BNSS.
BNSS. There's no MP MLA matters in Mizoram and Mizoram and Nagaland?
There are two matters in Mizoram,
Huh.
and they are of year 2025, and now PW prosecuting witness is going on as per the report, Lordship.
In Mizoram,
Yes, Lordship.
no MPM in it. Tole pari bhai, he has to be independent. Or have.
3 years.
You consume notice. Has to be a directorate of prosecution.
They'll be headed by the director of prosecution, who can function under the director control of the home department in the state.
But he will be an appointee under the state.
My lord.
So how a person who is an appointee of the state can be brought from the judicial department, from the judiciary? He is otherwise a person, member of the judicial service, Arunachal Pradesh Judicial Service, unless the High Court sends him on deputation. Isn't it?
Yes, my lord.
Possible?
Not possible without the information from the court.
Huh?
Without taking from the High Court,
Ah.
that cannot be allowed.
And to when he is functioning as LR.
He's functioning as an LR.
LR is the full
Already, this was said.
So you have to first find out whether there is a directorate of prosecution or not.
Lordship, kindly try to, Lordship, kindly give that punch to me for second. I just want to check out one thing because
Director one, example, creation of online temporary assistant. Deputy director, hearing from any local. Dear Selvi, director and assistant director. It is saying the state command may establish a director of prosecution consisting of a director of prosecution and as many deputy director of prosecution if things fit. Distribution of the district director of prosecution may যদি মেয়ে to apply করে ফেলেন তাহলে ডেপুটি লাগলে তো anyway we don't know now কিন্তু এলা তো লাগে ওকে দিতে হবে এলা না
Okay, so we will have this matter on some other day. First, the order shall contain one pertaining to this, we have seen this report which is given on 31/12/2025. We ask the registry to circulate our order, more particularly this order dated 23/10/2025 to all the courts wherein the matters are pending. I think then better senses may prevail upon the judges. That is one. And number three is we ask you to find out who is the director of prosecution now, what is the instruction as regards the formation of the directorate of prosecution, and as to whether there has been an appointment of a director of prosecution. And if the director of prosecution has been appointed, he shall be virtually present.
my lord.
Although we don't give any recognition to that. Let's have it on another day.
11 is concerned serial number, but the Dibrugarh case is 2003 case file.
Yeah,
That
2000
is 60 that these are the orders, man.
2003.
Very old, very old.
Yeah.
Very old.
Yeah.
Will not comment anything today, but it's for your on the an updated report on the next day.
Even more than 1 month, it may elevate to something to 11.
Those data are given very frequently, 5, 12, 22, 12. in a-
They are doing it, that's why we are not.
They're doing it,
participating.
but it's,
That was doing after this monitoring.
Let's have it on 24th of February.
Minor.
In the meantime, you get the.
Well,
Huh?
24.
Okay, we'll have it on 5th of March.
5th of March.
5th of March.
Sometime in the meantime dates, we have to progress to.
And Mr. Arkadev Chaudhary, any, as regards this thing, pertaining to these NIA cases?
Yeah, one case is from Imphal, Lordship, that has been transferred here. This is regarding the CBI case.
This is given to us, I think.
Ah. No, you, huh? Yeah, I said, yeah. No, this is-
I think that is involved. We have two papers.
No, one,
One is communication dated 15/1/26, another is 4/1/26.
yes, that is, if your Lordship will see the 15/1/26, Lordship. The first case is from Manipur. 2, 3 are from here, Lordship. And the Manipur, they have again given a separate status also of the case. That is a 4/1. CBI to DNI.
You know, case.
Yes.
Manipur case.
Huh?
Transfer করে-
I said,
That's it.
ठीक है sir, ऐसे से develop
It is a transferred case here or what?
Yeah, because of the conditions in Manipur, Lordship, the Supreme Court has transferred all the matters to. Yeah. You know.
So in the other two matters, there's some stay
Yes, Lordship.
by this court.
Yes, Lordship. 2 of 2012. Yeah. 2 of 2012. 2 of 2012. Gopendra Singh. This one is of 18. This is a transferred matter. And this 2 of 2012, that is also here, Lordship.
serial number 66. man. That is
Ah,
not
that is
one of the old
absolutely.
case.
And two are stayed here, that's all.
Yes, Lordship, that is of NIA. And so far as CBI is concerned, Lordship, perhaps I say CBI.
CBI.
CBI,
4/1 letter.
yes, that is of 5/1/26, if your Lordship has it.
There is 4/1 here.
In any case, Lordship, I will give the communication.
It's here, yeah.
That case.
That case.
In the list, I found 3 cases, Lordship. That is 81 of 2004, 3 of 2013 and 59 of 2010.
Z3 15, 16, 13, 14, November, October, specially resolution, 39 constitution intelligence for peace time and following numbers of number of
Eighty-one, 2004.
So these will be disposed of by 2026.
The first one, Lordship, it appears so.
That is what has been
It
given
appears
as
so,
to-
Lordship.
during the current financial year, current year. We'll have an update on 5th,
Yes, Lordship.
5th of March.
Much of it.
Yes, we have asked for what are the proposals now pending before the LR and also before the chief engineer.
Lordships, I have prepared a submission. Yes. We received the list, Lordships, from the learned Additional Advocate General. And pursuant to that, we have prepared a detailed status of the projects that has been sent to the Judicial Department. Lordship will find the list, a detailed list at Annexure A. We have basically categorized Lordship as a court building and residential building. And we have put it by the date on which we received those proposals and the status.
When we come to serial number 277.
Lordship.
This is an administrative approval issued on 8/1/2026
Lordship.
by the High Court. By the
No, by
state.
the Judicial Department.
And it was communicated to you on 31/5, na?
Yes, Lordship. On
So
23.
these are the recent ones. I could
Yes.
see a few. Now, which are the ones which are pending?
It's a mixed actually, Lordship.
A could not be issued. These are at two.
But in fact, we had prepared a compilation of, which are yet to be
512, I think. We had prepared a compilation wherein administrative approval has not been issued. These are part of the list that has been submitted by the planner.
All these cases, no administrative approval has been issued. Huh?
That is.
The annexure B lordships can have a look at.
Pending for issue of administrative approval and compensation under the BC. Educated the distribution line. Portfolio is a common for a family. Reducing conferences. Audio, video and conferences distribution is a simple way massive link. Conference is complete. Go ahead, there is a letter of go ahead.
Mr. LR,
Yes,
tell
madam.
us about the Dhemaji thing pertaining to the transformer 315 kV. Why the administrative approval has not been issued after a long time? The boards are functioning without electricity.
It was burned down, then it was brought by from some other transformer. Now, anytime accident may happen.
We have issued the lordships. Dhemaji. 300.
Mr. Das, is it here as regards the Dhemaji thing?
This search window.
Huh?
Why don't you make a district wide? Then it will be.
Because very difficult that
We
way.
got this yesterday, evening, and therefore hurriedly I asked them to prepare this. It would have been handy, my lord, had it been district.
District wise, you can have reference,
I
because we are saying budgetary,
Correct.
yeah, then we can see,
There is a budgetary constraint, lordship.
that's fine. But administrative approvals are also pending.
That is because of the budgetary, because the budget has to be available, lordship. And once the administrative approval is issued, lordships, unless the amount is exhausted, further budgetary approval cannot be issued. $370. Recent G2S.
Yes, Mr. Das, why you are bringing this number 15?
Serial number?
15?
Proposed judicial guest house at Testwood.
This has already been abandoned.
we have not prepared this, Milo. This, the main list was given by the government. And from that, we have just segregated. Wherein, Milo.
Anyways, this is the issue out here. Mr. Eller, we'd like to ask you another aspect. I could see out there regarding now this proposed judicial guest house at Tejpur now has been put out there at Kaziranga. Out of that, around 997 lakhs have already been given the administrative approval, as well as also the other approvals have also been given by the Chief Secretary to that effect by the Special Finance Committee. No, 997 lakhs have already been given by the Special Finance Committee. Subject to there are some undertakings to be given by the architect. The architect thereupon has given those undertakings, how it would be done as to uses of the earlier, some buildings are there and all these things are there. Now, pursuant thereto, this, the chief engineer has also placed it before the commissioner and special secretary for the purpose of granting the approvals. And it has been, we are told, in the global head. No?
It's now in a global head.
Global head. Now, why it is just stagnating out there for some time? That is what a letter has been also issued by the chief secretary. The chief engineer also has been brought to our attention. Now, this is an aspect which needs to be looked into.
I'll find it out.
Mr. B. Gogoi, this needs to be looked into because that is what I could find out on that day when this proposed judicial house at Tejpur, which is there, this is an abandoned thing.
Serial number, the chart.
No, serial number is 15. No, 15 is abandoned.
15 as well.
I don't
Their
think-
serial number.
Their serial number 15 is abandoned. But be that as it may, I'm saying about this is now being abandoned and brought it out there. Now the Special Finance Committee has also given 997 lakhs out there. And there were some undertakings to be given. Now the thing is, if you keep on delaying it, that is a particular guest house which was, I think, in 2023, no? 24. 24. Foundation was laid on 3rd of March. Now, the thing is, by the time you start anything, in spite of the approval being the special money, if you start later on, then the only thing which may happen is it will go to more higher amounts.
Escalations will.
Again, revalidation, question of revalidation will also come.
So therefore, no, I think it may not be. Global head of
Global head is no reason.
Yes.
no revalidation is required. But the thing is, it will go for escalation.
Of course, it will come.
Of course.
Because this was done in 2025, early part. So therefore, you need to look into that aspect on the next it.
Yes,
Serial number 191 of the funds given by the LR. Serial 191.
191.
639 at the guest house.
Embassy is the 639.
639 one.
Or
191 is the guest house of test.
LR report.
This
39.
could not be issued. Now, this
We-
is another thing. This is, I don't think this proposed 191 is no longer there.
It is of, my lord, it's 17/1/2023. So you will have to be
Therefore,
revalidated.
no, therefore, there's a full court resolution also, although the land is there,
No.
but we don't still have this proposal out there. And this money which was initially allotted is being reappropriated, or we have requested the government, and on the basis of that, the government the Special Finance Committee has done that. So things needs to move. And what is
639.
639.
I've seen on
This-
8 of
8/1/26.
On 8th of January, we have issued.
Kuntu?
Electrical.
Oh, it has now got the administrative approval.
Yes.
So that means we have the budget. Chalo. I think this needs to be rearranged in a.
district wise.
Yes.
Then sub-category, construction, renovation, electrical. I think you
Yes,
should do, then we can see the preferences. That
Including the
if
date
there
of
is
proposal.
budgetary provision, we can give preferences.
Yes.
These are the important things.
We'll make it.
That is important, so that you have done it.
Yes, my lord. We'll rearrange the list, Lordship.
The importance is, prove that,
All are important, they're not
that's
saying.
what I have in my mind. They have said in a affidavit that budget is budget constraint. I find it difficult to buy this contention. Budget constraint, they have said in the affidavit that most of the proposals, they could not give administrative approval because of budget constraint. There are proposals of 2022, 2023. My lord, when my number will come, my lord? The heads are shouting that when my number, replacement of 11 kV cable serial number 8 in my list. 6 lakhs. The number is yet to come, my lord.
Revalidate serial number 8.
Now, certain things are no more required. See, this is 2023. Repairing and renovation of rooms of judicial court building, Shivsagar. Now that has gone. New building has come. No repair and renovation is required. So this, your homework is not, you have just made it from up. They will not like to have this kind of documents. Those are not relevant today. We have made a list of how many? Hundreds of pages.
We have just given from the High Court list we have received from the
No,
High Court.
you should do it.
Add a
We are
lump.
not here to waste judicial time. If you include all those which has no relevance at all. On a cursory view, we have found out this. How many?
There are headings like repairing renovation of electrical system and electrical session desk complex at Karimganj. Requirement is 19 lakhs. 2023, the approval was given. That is at serial number 35. Sorry, 34.
Providing solar power to the new judicial code na boka. In দুজন পদ আছে। মানে 22 লাখ খাওয়া এখানে বসে
We will request both of you to look into this and give on more priority. There are
Yes.
certain things which have priority, which have less priority. Just for example, as my brother has just brought out,
Serial number 24.
serial number 24 of his list. His list.
His list.
Now, providing solar power plant at new judicial court, so and so, ground floor and first floor. 22 lakhs 77,000. This was communicated on 4/3/2023. Now, in the year 2025, this particular building was inaugurated. Now, after this inauguration out there, we are only having 2 judges. Although we have requested the government to have additional judges, taking into account that there are 6 courtrooms out there. Then also there will be 3 judges. So therefore, this may take some time, it's okay. The government does not want to give more emphasis on solar power, although there are emphasis that one day and another for 2-3 years, Assam will have 3,500 megawatts of solar power. It's a different thing. But whatever may be, so they don't want to give emphasis, is okay. But that is not of really so much of importance rather than the certain other aspects which are of emergent necessity. Just for example, as my brother has said, the Dhemaji court building is functioning without a transformer. They are lending it somewhere from some other place. You have issued it good on 8/1/2026. So similarly, I think these are to be chalked out, Mr. Das.
Yes, sir.
Once you chalk out with the registry, which is of more urgent necessity, we take it up on more, give more emphasis on that.
Correct, sir.
Which are where there is no administrative approval, it is required.
So in a way, logic is correct because our need will be aware. What
Yes.
is our need?
Yes.
That's true, my lord.
Because this was done at the time, just for example, the Bukakhat was done in 2023, much prior to the completion of the project.
Correct.
We have 3 years have gone by, but it has not happened. Now with this government of India giving more impetus on power, they may think about it. That's another aspect of the matter.
See, some of the projects are, most of the projects are become redundant, come to serial number 30.
30.
Why have you incorporated all this in this list?
Prepare an innovation of Shivsagar old building now occupied by CDM so and so.
See,
This is 24, we have.
23, this was done in 2024, 24 last part. It has been, a new building has come in.
So this can be, changed, and it can be corrected very
It
well.
is
I think
spoiling
Lordship,
our judicial time.
No, my lord, so far as this bunch is concerned, this has been provided by the registry to the honorable court today, not by the my lord LR.
No, we want,
We'll have to sort out,
according
yes.
to what are
No, no,
pending,
yes.
forget about registry.
No, Mr. Gogoi, here also, this bunch also contains the same.
Same thing, no, whatever list was provided, we have my lord placed it before.
This also contains the same. Just for example, that the judicial guest house at Tejpur is here also.
Yes.
And my lord, because
So
we
both
lack information, Lordship, that's the handicap that we are having.
Why you lack information?
This regarding the project's pendency, I mean, the
Tezpur, if LR says, I'm not aware of this Tezpur guest house,
no, that is.
it will be difficult for us.
LR is the bridge
Please.
between the judiciary and the executive.
My lord, we
You are the
can,
bridge.
if I may suggest, my lord, Lordship may permit, we can have joint sitting with the registry and sort out
Yes.
as
We
instructed by
expect
your Lordship.
that
Yes,
day.
we'll do it by next day, Lordship. By chance.
One more
That
request,
is
my lord, regarding that 2012 visit of your lordship, my lord.
Mm.
Whatever inconvenience lordship has found, it should be reflected so that we can act upon. Otherwise, my lord, that coordinating, my lord, will be difficult. Some observation my lord, regarding shifting of my lord, the administrative tribunal, if possible, to another location, as well as the revenue board. About 7,000 square feet will have to be given to them in the first floor. If that comes up, my lord, every problem will be solved. But my lord, without that, some my lord, hint in the order to bring all the departments together for a decision, because ultimately it was their building. If we try to, some observation, if possible, that will work. My report is there before the lordship. That lordship can consider, and in view of that,
Have you proposed that?
yes, it's there. It's there.
We give a report to him, give a copy of the report to him.
Okay.
And let us have it again sometime around. Let us again have it on around 5th of February.
Well,
In the meantime, you give an update on that report which he has
Yes.
given.
lordship.
And LR and the register administration and you sit out there and find out which is of more importance,
Correct.
which needs an urgent intervention of this court. Thereupon we can further proceed. If you give us these 700 or 800 names, it makes no sense. It is finding a needle in the haystack.
And my lord, proposal will have to be revalidated, my lord. If at all, whatever urgency is required, say of 2023, that
Hmm.
proposal has gone, my lord. It will have to be, my lord, revalidated and it can be moved now.
And
It's
Mr. Gogoi, I'll put it on the order, just find out as regards the what has happened out there in that before the commissioner and special secretary as regards the judicial guest house Kaziranga.
Kazir.
I'm only worried because this amount has already come up at 997 lakhs is there. Now, if it is delayed, it will lead to escalation and thereby it will have a lot of.
That escalation we can use in some other good purposes.
So this unnecessary spending of money also. Now we could see out here the ACs out here, the 14 ACs, the summers are coming out there. 14 ACs, but the 14 ACs is 35 lakhs. But that's how do you take care of that? 35 lakhs for 14 ACs? We'll request Mr. B. Gogoi to have also look at to which are required for urgency. Although this is a request.
Lordship.
It's a direction to Mr. H.K. Das.
My lord,
It's a
that
direction to Mr. LR, to the LR as well as to them
No,
to
my
look
lord,
into it, which needs more primacy. But
My lord,
we
if
make
that
a
list is
request to you,
furnish
Yeah,
me, my lord,
yeah,
7 days
which
prior
are
to
of
the
urgency,
date, and I
how
can
it
have
can
from the
be.
finance also, if at all any proposal
Yes.
is sent.
You prepare.
If it is given to me
it,
earlier,
uh,
before 5th, I can have it from the finance also.
Yes. I'll pass the order again. We have it on 5th, this matter.
So he needs 7 days time from the
Yes,
date of receipt. So before that, you will have to.
I will.
Next week itself will. provide.
Yes, and this, the other matter is on 5th of March.
Yes.
This matter is on 5th of February.
5th of February. Fine.